It's a little bit after 10, and I'm going to call the Judiciary Committee to order. And as the first order of business, Chair recognizes Representative Tripp to lead us in the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right. First, I want to thank, we have a number of substitutes, as you may recognize. I want to thank all our substitutes on both sides of the aisle for your willingness to be here today and participate. I also want to thank Representative Tur, who is standing in for Representative Kutab, who could not be here, as our clerk. That's a very important position, and I really appreciate your efforts in that regard. First, I'm going to launch the hearing on HB 1416, prohibiting a bill that relative to prohibiting certain government regulations regarding pregnancy resource centers in connection with abortion and contraception service offerings. And the chair recognizes the prime sponsor, Representative Farrington. Yeah, it's part of this. Yeah. Okay. Representative Farrington.
Good morning, and thank you, Mr. Chairman. If you support the principles of free speech and religious freedom, then you should support this bill. HB 1416 is straightforward, both in its purpose and its scope. It ensures that pregnancy resource centers in New Hampshire can never be compelled by the state to perform or refer for abortions. It does not regulate abortion. It does not prevent women from accessing abortion facilities. What it does do, it protects a constitutional principle that the government should not use compelled speech and weaponize themselves against a private organization. Right now in New Hampshire, there's more than a dozen, about 19 different pregnancy resource centers across our state, and they serve women facing difficult pregnancies. They provide resources, diapers, food, parenting classes, counseling services, sometimes medical care, and ultrasounds, all free of charge to women and families. Their goal is to help women choose life. So then why do we need this bill? Across the country, there have been coordinated attacks by state governments on pregnancy resource centers. Just take a look south across the border. The state of Massachusetts recently launched a $1 million taxpayer-funded campaign to put pregnancy resource centers out of business. This ad campaign labels pregnancy resource centers as scamming women, which we know just is not the case. And so then we look at other states. We look at Colorado. They passed a bill that prevents and even penalizes doctors that want to prescribe progesterone, which is used to reverse the effects of chemical abortion. The state of Illinois, they passed a deceptive practice law, and that allows their attorney general to impose $50,000 fines on pregnancy resource centers that do not refer for abortion. Both of those laws were blocked in federal court. This bill prevents any of that from happening here in New Hampshire. Fundamentally, this is a free speech bill. And so I'm sure that we will hear from the pro-abortion lobby today, and they're going to label pregnancy resource centers as deceptive, as scamming, as fake science, as just propaganda from the pro-life movement. Well, I want to provide some context. Across the country, there are about 2,800 pregnancy resource centers that provide these free resources to women. Over 62,000 people work at these pregnancy resource centers, and of that number, 70% are volunteers. But here's the most compelling stat. Of all the women who visit these pregnancy resource centers, 97% of those patients reported having a positive experience. Again, this is fundamentally a free speech bill. The government should not be coercing pregnancy resource centers to violate their moral conscience. And with that, I would welcome any questions from the committee.
Questions for this witness? Yes, Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. I notice you've been very careful to use the phrase pregnancy resource center, but the bill actually uses the term medical pregnancy resource center. And I'm wondering how that term is defined in the bill. Thank you.
Could you reference the line? Because I'm looking at line 6, line 8, line 11, and it references pregnancy resource centers. In the definitions section, I define pregnancy resource center. That's on page 2 at the very top, line 1. Pregnancy resource center means a private nonprofit facility that provides pregnancy counseling. And then you can read the rest. On line 14 of page 1 or page 2? It says it, so not all pregnancy resource centers provide medical services. Ultrasounds are one example. So some do, some don't, but that just falls under the broader category of pregnancy resource centers.
Follow up?
What would be the medical services that a medical pregnancy resource center would provide?
I just mentioned ultrasounds. Some of them provide abortion pill reversal, which is the process of undoing the effects of mifepristone, which is the first pill in the chemical abortion process. Doctors can prescribe progesterone, which is a high dosage that counteracts the mifepristone, and this has been proven to be safe and effective. Dr. Delgado did a study of, I think it was 754 women that attempted to reverse their abortions in that study, and he found that it was 68% effective. So it's not 100%, but when women want to, for whatever reason, when they realize that that was not the best decision, they can go to these facilities in hopes of being connected with those doctors.
Have another follow-up? Go ahead.
Thank you. Would there be any other medical services that a medical pregnancy resource center would provide other than the ones you've outlined?
I know that we have several pregnancy resource centers here today. They can speak further about that. Some of them are under the direction of a doctor, an MD. Registered nurses work at these facilities, so they can testify to that as well.
All right. Representative Horton.
Thank you very much. Representative Barron, you made a point of pointing out that the services are free of charge, which I guess you mean by free of charge to the clients who show up. So if they're not, so where is the money coming from? So obviously they're hiring nurses or even providing prescriptions. There's obviously some money involved. So where is the funding coming from if they're not charging any fees to the clients?
So to my knowledge, not a single pregnancy resource center in the state of New Hampshire accepts any government funds. It is mostly from private donors.
Other questions? Yes, Representative Birch.
Thank you, Mr. Chair. Thank you, Representative. To follow up just a bit on Representative Manos' question, and talking only about the coverage of your bill, which is New Hampshire and not every other state. When you talk about defining pregnancy resource center as providing medical care, which is on page 2, the first couple lines, you mentioned counseling, but you didn't mention medical care. For pregnancy resource centers in New Hampshire that you want to protect to be able to give medical care, are they mandated to follow the requirements of HIPAA?
Are you looking at line 1 on the top of page 2?
I'm looking at
Because again, it doesn't mandate medical
line
care.
2.
Line 2, you will see that it says or medical care.
Right, so you're including medical care
Yes.
in your definition.
Again, some pregnancy resource centers, some offer medical care, not all of them do. But to answer your question, they are not required to be licensed by DHHS in the state of New Hampshire. Some of them may, I'm not exactly sure, but in regards to federal rules or regulations, these facilities are under the direction of often MD doctors or PAs in those instances, and so they would work directly under that supervision.
If I could follow up.
Yep.
I asked specifically about HIPAA. So if somebody goes in to one of your medical pregnancy resource centers and they talk about private stuff or their own identity, are those people coming in protected by HIPAA?
I think there are several pregnancy resource centers that can testify to how they keep information confidential.
If I could follow up, just one other thing.
Sure.
Thank you. Thank you, Mr. Chair. You referred to this as a freedom of expression kind of bill.
Sure.
And I know our committee, and I'm sure you're familiar with it, has dealt with rights of conscience for people working at a pharmacy that may dispense certain drugs and the like. And I understand you're in favor of it. So I'm wondering about the rights of conscience. Does that also apply to people who work at the pregnancy resource center who may have a different personal philosophy? And I'm referring to page 2, lines 29 to 31. And doesn't that deny employees the rights of conscience at a pregnancy resource center, but supposedly not the right of conscience at a pharmacy or a healthcare place?
So to my knowledge, that bill was retained last year. Maybe it's still in the committee. I'm not sure. The right of conscience bill regarding performing abortions. But I mean, in terms of the employment of these pregnancy resource centers, they're private organizations and they can hire who they want to hire. They're not going to hire somebody who does not align with the mission statement of the company. I mean, that's common sense. Why, as a business, would you hire somebody that directly contradicts your mission statement? So I think that's pretty straightforward there.
Thank
All
you.
right, other questions? Representative Maddox.
Thank you, Mr. Chair, and thank you for taking my question. As you just stated, these are private organizations, correct?
Yes, ma'am.
So doesn't the First Amendment already apply to them? Why is this bill necessary?
There's something called compelled speech, which is when the government forces speech onto somebody. And so in states like Illinois, where they have been borderline forcing pregnancy resource centers to refer for abortions, that's a violation of the First Amendment.
Other questions? So I guess I have a question. On page 2 of the bill, in section 332.02, the bill says, basically sets out a list of things that no state can do with regard to a pregnancy resource center. So my question is, if we were to pass this bill, let's assume, and I have to say candidly, I hope this is not the case, but let's assume that next year the legislature is not in control of the Republican Party. Wouldn't it be
I see your point.
Wouldn't it be very easy? You've given a roadmap
To repeal the law. That's right.
they'd simply have to, the law could be amended to simply take out the word not.
It's a good question, but there's an important distinction because say the governor goes from Republican to Democrat and Republicans hold control of the legislature. Well, the governor is the head of the executive branch. And so then DHHS can start implementing agency rules that start to force these pregnancy resource centers to act or to talk about things in certain ways.
Okay, I'm not quite sure how that I understand how that answers my question, but that's okay. Other questions for this witness? Seeing none, thank you. All right, With regard to the other, because we are under some time pressure here, with regard to the other witnesses and for this bill and probably other bills as well, I'm going to impose a 2-minute time limit, please. So next, I'm going to call on Chris Ager.
Thank you, Mr. Chairman, and I'd like to thank the committee for all the volunteer work that you do. I just want to tell one story. In 2024, in the space of about 10 days, a team of 5 of us, 4 women and myself, visited 8 of the pregnancy centers in the state. And we did that because we wanted to find out how we could help women who are in need. And I was blown away by the competency, the caring, the commitment of these 8 different centers, from Keene to Rochester, up to West Lebanon. The people there were just incredibly caring about people. And I said, if you ever need help, please let me know. I was that impressed. I've donated to those centers. They are all from donations. And so when this bill came up, this is how I want to help, is to testify that anything that you can do to help allow these centers to continue to do the great work they do, please do so. I urge you. We've met some of the clients, some of the women and men. They all cater to both women and men, the families, and they make a difference in their lives. And the one thing that they do that I was the most impressed with is they have boutiques. And I was like, what the hell's a boutique? I didn't know. It's a little store, and they have little teeny baby clothes, strollers, all kinds of things that a young family would need, but they have to get credit to get those things. So my wife makes little blankets, and so we make blankets now and get them to options in Manchester and Nashua, because we care so much, and they do such a great job. So anything you can do to help them stay in business with no taxpayer money, I'd urge you to do that. Thank you very much.
Thank you. Questions for this witness? Representative Bursch.
Thank you, and thank you for coming today. It's appreciated. If it's true, and I understand that it is, that there's never been any legislation proposed against pregnancy resource centers, and if it's true, as we've heard, that they are another private organization, why do we need to do legislation for this particular private business that we don't do for any other private business? It's not under any kind of attack or any kind of legislative attack.
So the only thing I'll say to that is that there were, in the 2024 election, there were 3 leading political members of the Democratic Party who had in their literature that they wanted to minimize, reduce, or put out of business these centers. So there were at least 3. 2 of them were already mentioned, and by Representative Farrington.
Other questions? Representative Smith. All right. All right. Thank you very much. Next, I'm going to call on Representative David Love, please. All right. All right. Thank you. Next, Lydia Boris. No, I'm sorry if I'm pronouncing this incorrectly, but having trouble reading.
Turn the microphone on, please. Thank you for allowing me the opportunity to speak to you today. My name is Lydia Borsi. I'm a resident of Lebanon and a second-year medical student. I want to begin by acknowledging something sincerely. Every pregnant person should have access to all the resources they need to make timely and informed decisions about their pregnancy. Many pregnancy resource centers are run by folks who truly want to support pregnant people and their families, but that's not what this bill is about. The issue before you is narrower and more practical, whether the state can ensure basic honesty and safety when someone seeks pregnancy-related care. This bill would take away our ability to ensure women have access to accurate medical information. Help us protect patient safety. The bill specifically mentions protecting counseling about treatments described as reversing medication abortion. Mitigation abortion consists of taking 2 pills, mifepristone and misoprostol. Mifepristone blocks progesterone, and so there's been some studies about whether administering progesterone after taking the first pill would help reverse the pregnancy. Case series, which are the studies that have been mentioned today, are the weakest form of evidence. So taking progesterone or not taking the second pill at all right now are equivalent. The American College of Obstetrics and Gynecology warns that abortion reversal is not supported by reliable scientific evidence. Regardless of your views on abortion, I hope we can agree that pregnant patients should not receive medical guidance from people without appropriate training about interventions that have not been shown to be safe or effective. As a medical student, I offer support to pregnant patients weighing options and making decisions that often seem impossible. My role as a student now and physician in the future is to be a source of comfort and accurate information. Healthcare providers should be required to provide accurate and complete medical information. If I were pregnant tomorrow, it is what I would want for myself and what I would want for my family. My little sister has type 1 diabetes, a condition that would make a pregnancy incredibly medically complex. If she walked into the pregnancy center in our neighborhood hoping to receive medical advice, she could be missing key information about what services are available and what her options are should this bill come to pass. This information, getting it in a timely manner,
Sorry,
could
ma'am,
save her
your
life.
time is up. All right, thank you very much. Questions for this witness? Yes, Representative McFarland.
Thank you, Mr. Chairman. Could you point us, please, to the page and line in this bill that would have any change, any impact on the way that these services are provided today, as you're describing?
What I am mentioning is the fact that the bill states that we should not prevent. So, as I provided today,
Can I take that as a no then?
no, we would not want to add restrictions that would prevent the state from protecting pregnant people in the future from receiving medically accurate information. This bill specifically mentions the abortion reversal pill.
Other questions for this witness? Yes, Representative Horgan.
Thank you very much. The prime sponsor was complaining about compelled speech. So if you found in your studies to be a doctor, and good luck with that, are there areas where there's things you have to say and points you're required to make to patients or other you're working with because of regulations? So is it entirely unheard of that there are things that you're required to tell people or not?
Right. There are many states where people have to have an ultrasound even if they do not want one, even if they've chosen to have an abortion. There are states when people are required to speak about the abortion reversal pill even though there's no evidence that is safe and effective yet. We don't want to be that state.
Yes, but and then also in a more global area, are there other areas of medicine where there are things that you, as a doctor, are required to tell people because there's regulations saying that you have to tell people of their rights or their responsibilities or other issues? So is that
Right.
that accurate that there are other cases like that?
Right. People are, doctors are required to obtain informed consent before any medical procedure. So when a patient makes a decision, we have to weigh the risks, we have to weigh the benefits, and we have to provide all of that information. And this bill would mean that pregnancy resource centers are exempt from that.
Right. Other questions? Seeing none, thank you very much. Oh, I'm sorry, Representative Petterno. Sorry.
Thank you, Mr. Chair, and thank you for taking my question. I'm confused about what you're saying about the abortion pill reversal, because if you take it and you lose the pregnancy anyway, you lose the baby, then nothing changes. If you take it and the baby survives, wouldn't that be proof that it was not only safe but also very effective?
Yes, so thank you for that question. I can clarify. So we do not know because case series with no control groups are among the weakest forms of medical evidence. And as studies that were intending to evaluate medication abortion reversal in controlled settings was ended early due to safety concerns among the participants. So we do not know what receiving large doses of progesterone could be doing for other organs in the person's body. And so that's a safety concern number one. And the second is currently there's no data to support that taking progesterone would increase your chances of retaining your pregnancy. What is increasing your chances of retaining your pregnancy is not taking the second pill, which is misoprostol, if you choose to stop.
Follow up?
Correct me if I'm wrong, but isn't progesterone used to maintain pregnancies for women who have not initiated abortion procedures? It's my understanding that it is used in medical situations where the pregnancy is threatened under normal circumstances, natural circumstances.
That might be the case in smaller doses, but the randomized trials that have been done on this, and I can share those resources with the committee, administration of this medication alone can slightly increase the chance of ongoing pregnancy, but it can also, depending on how high you're doing, it's a dependent response. And we do not know yet what the doses that would be safe for people that have taken mifepristone. We do not know yet for this specific circumstance what the safety implications are. So we cannot be telling patients what to do based on information that does not exist yet.
Other questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Paul Galasso, please.
Good morning, everybody. Before I share with you briefly my plan comments, I just have to make a comment or two based on what I just heard. I'm not a medical person, but I have over a decade experience working at the Pennacook Pregnancy Center. We see several ambulances. We saw one 2 weeks ago, taking women out the back door, bleeding profusely, bringing them to the emergency room, coming out of Planned Parenthood. We have women that have worked with us that have talked about the fact that when they went to Planned Parenthood and did abort their children, Planned Parenthood does not provide information on the other choice. None. If they're asked to provide an ultrasound, it's only going to be provided if the woman that is visiting Planned Parenthood intends to have an abortion. So the criticisms about pregnancy centers not offering sufficient information to support both potential choices is being just violated egregiously by Planned Parenthood. So, okay, let me just put that aside. My experience at the Pennacook Pregnancy Center in Manchester has been nothing less than very gratifying. I've been there, as I say, 11 years. We've helped, in my time there, thousands of women. These are women that come to us voluntarily because they're seeking information. And beyond that, what they receive is compassion, care, and experiences with people that have only good intentions.
Thank you very much for your
Yeah,
time.
okay. Okay, well, I'm glad I spent the time talking about some of the things that were just said that weren't right.
Questions for this witness? Seeing none, thank you very
Okay,
much.
thank you.
Next, I'm going to call O. Young, please.
Thank you for allowing me to speak. I'm Dr. Og Young, retired OBGYN, practiced in Concord for 40 years, past president of the New Hampshire Medical Society, was on the general council for 20 years representing obstetricians in this state. Finally, I taught for 40 years at Dartmouth Medical School. When third year students come down and do their OBGYN clerkship at Concord Hospital. Short story. A couple presented to my office years ago with a long history of infertility. An evaluation revealed that the woman had severe pelvic scarring resulting in blocked fallopian tubes following a serious pelvic infection years before. Before IVF, I operated, removed all the scar tissue, was able to reopen her fallopian tubes. And remarkably, a short time later, she was pregnant with an intrauterine pregnancy. Ectopic pregnancies, she was at high risk for that, given her scarring. An evaluation was uncomplicated. Her pregnancy was uncomplicated, and I was present for her delivery of a beautiful baby girl, Anna, 9 months later. She continued to see me for her annual exams and shared stories of Anna and the joy she felt being a mother. One day she confronted me about abortion. She said, "I don't understand how you can help so many couples achieve pregnancy and still provide abortion care." I explained that I felt strongly women should be able to choose if and when they'd like to make family. And if they elected a termination, I wanted to provide that care in a safe and private setting. Turned out that my patient was a volunteer at the Pregnancy Resource Center. And after that visit, she did not come and see me for years.
Doctor, thank you. I'm sorry, but your time is up. Questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Catherine Kelly, please.
That was 3 minutes?
That was 2 minutes.
I misunderstood. I thought it was 3 minutes that we had to speak.
I'm sorry. I'm sorry you misunderstood, but I did say 2 minutes.
Okay. I would like to say this woman opened my eyes.
No, I'm sorry, doctor. We have one rule that applies for everybody.
Hi, I'm Catherine Kelly from the Pennacook Pregnancy Center. We opened that 13 years ago to help women with pregnancies that were planned and unplanned. And regardless of how many kids they have or whatever they want to do, everything we do is free. Let's get back to what pregnancy centers do, not what we don't do. Diapers, strollers, car seats, formula, everything. We help pay utility bills to keep the heat on for people. Woman calls from the ER crying. She's got a prescription for a baby. She has no money. We give her the money. We pay the prescription. That's what we do. We help people. As far as some of the other questions, everything is confidential. The volunteers were all funded by private donations, small donations. All the volunteers that are there, they sign a covenant, okay? Everything is confidential. When somebody comes in for a pregnancy test or whatever, they sign a statement. Everything is confidential. They accept our word that we keep everything confidential. We don't give their names out or their problems. We help women with domestic violence that have been thrown. If they're leaving a house, they have nothing. We give them everything that they need. We work with the Manchester Health Department, the Amoskeag Health, Waypoint. We get referrals from all these bigger organizations. We're small. We've been there 13 years. We're on the corner of Pennacook and Chestnut Street. We're in the inner city, and we help people that walk there. They need strollers, whatever they need. We try to get them what they need for free. So that's, it would be a shame to close people like us down. All we do is help people free. No tax money, charity. That's all I have to say.
Right. Questions for this witness? Yes, Representative Smith.
Thank you for that uplifting testimony. It was terrific to hear all the things that you do. And I very much appreciate it. And I think all kinds of organizations should be doing what you're doing. My question is, that has nothing to do with this bill. Have you any reason to believe that the legislation as proposed here is necessary? You have been for 13 years able to do everything that you want to do. And I think That's terrific, and I bet lots of other people here think it's terrific. And where does the idea come from that somehow, suddenly, there are efforts to interfere with your ability to carry out the work that you've been doing?
I'm trying to be proactive. I have a friend, Bethlehem House down in Massachusetts, and she's fighting the fight down there, what's going on. Just trying to be proactive and take care of the people that come to us. We don't want anything to change negatively, that people can't get the charity, the stuff that they need, whether it's formula, car seats, whatever they need. That's all, just being proactive.
Other questions? Yes, Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. I'm wondering whether you're required to follow HIPAA.
We do follow HIPAA. Why wouldn't we? We're not medical. I never said we were medical. Everything is confidential.
Sure.
So you're not medical?
I don't consider us medical, no.
Thank you.
Other questions? Seeing none, thank you very much.
You're welcome.
Next, I'm going to call on Kathleen Yaninian. Sorry.
Good morning. I might be a little repetitive, but please, thank you for your patience. I'm a volunteer at Pennacook also. And I want to give you a little glimpse of who we are and what we do. Of course, we're a 501c3, operate on donations only. All staff are volunteers. They don't receive any pay, except maybe a bigger heart. All we do is free, never charging any client, any woman, men, or children for any of our help. We're located in the inner city of Manchester, intentionally to assist those who must walk or take a bus and have no transportation otherwise. Our building is very old, very large, 26 apartments, always having problems, but we deal with them. And we're in a kind of a storefront on the bottom, and many of those other storefronts are vacant, to give you an idea of what the building looks like. Recently, we had the fire department. It wasn't wired in correctly, so if you pull the fire alarm, it would not go to the fire department. They had to rewire the whole building. So it's kind of that building situation where we're at. But that's where we want to be, where the people are that need us the most. When you walk through our doors, there's a small waiting room. We have 3 chairs. We've got donated furniture. We're not sleek. We're not beautiful. But that's all we're going to spend money on because we need it for other things. We have some books. We encourage little children and parents to take them to help their education. Those we serve include the poor, the homeless, immigrants, undereducated, in drug recovery, difficult relationships, and some violent relationships. And even some women just released from prison, and they all come to us, and other organizations refer to us. We supply, as Kathy mentioned, diapers, wipes, all that stuff, so I won't go through that again. Just a little snapshot, I had 3 women from the Congo come yesterday.
Thank you very much,
Oh.
Mary. Your time is up.
Okay.
Okay. Questions for this witness? Yes, Representative Horgan.
Yes, you mentioned you're in the inner city of Manchester, and I know you have a bilingual website, which is which I think is a good thing. But how has your work been affected by the uptick in immigration, the changes in how immigration law is enforced over the last?
Tremendously. We have a book. We do a sheet on each person so we can track diapers, because we can't give 10 diapers a month to one person and then no diapers because we don't have them. We've had over 500 over 500 clients last year, and we're already over 100 in the first 2 months. The need has been growing and growing. It's tremendous. And they're not being fully provided by the government. So we're there to pick up the pieces.
But you still be able to continue work regardless of the immigration status of the.
Oh my gosh,
yeah.
yes. We don't, no.
That hasn't been a problem for you.
No. That's a problem as far as what?
Well, just with maybe people not wanting to go out in public to use the services, or even possibly ICE agents coming in and trying to dab people.
We don't ask anything. I had just one. Children weren't in school. It was a brother's kids or something, and he wasn't illegal because they came in, and I said, "Well, these kids don't go to school." She volunteers information. They're very, very open with us because we're grandmothers, mothers, and we try to do things in a caring way. And I said, oh my gosh, so we give them extra books, but there's no scare thing. We use Google Translate. It's wonderful if we can't get anything else. But we're happy, and we have 3 beautiful little girls, and they love a little Christmas stuff. So we're very blessed.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Kelly Lindholm, please, or Lundholm.
Honorable members of the Judiciary Committee, thank you for allowing me to speak today. My name is Kelly Youngholm. I'm the Executive Director of Care Women's Center, a Pregnancy Resource Center in Concord. HB 1416 in Section 3 states what we do. I want to talk about that today in real life. Just last summer, we had a 22-year-old woman come into our center. She told us that at 17, she became pregnant. She was scared and she felt alone. She believed that she had no support and not many options. She obtained the abortion pills and she took them as directed. When she was in English class, she began to cramp and she began to not feel well, so she asked to go to the restroom. In a private stall in her high school, she delivered her 10-week baby. She was a child herself. She wasn't prepared for what she saw. She could see the little tiny baby, that it was a baby. She was shocked and she was traumatized. So in a panic, she flushed. For 5 years, she carried that with her alone. She struggled with depression, anxiety, and recurring trauma. She told no one. She believed that she would just live with that forever. And then she found our center. She found our center not because we advertise politics or because we protest, but because we offer help. She joined our 8-week post-abortion recovery program, and for the first time, she told her story to women who understood her and in a confidential space. She was met with compassion, not shame, care, and not judgment. At the end of the 8 weeks, she said to me, Kelly, for the first time, I feel like I can breathe. Regardless of your stance on abortion, that's not why we're here today. Women who experience these types of trauma need to go somewhere and need to seek help. Not everybody who has an abortion wanted that abortion, and there isn't anywhere for them to get help. In our center, we can give them that help. We do not coerce. We do not do anything we have been accused of doing. I invite any of you to come to our center, even unannounced. We will welcome you. You can check out what we do. We provide
Thank you, ma'am. Your
okay.
time is up. Questions for this witness? Representative Andrews.
Thank you, Mr. Chair. Would you please explain to all of us why this bill is necessary?
I think just that was stated already. You're going to hear from a pregnancy director from Vermont who lives in New Hampshire but runs a center in Vermont, and what they've gone through, what Massachusetts has gone through, what Maine is starting to go through, Virginia. It's just a safety net for us.
Other questions? Oh, I'm sorry, Representative Peterno. Sorry.
Thank you, Mr. Chair, and thank you for taking my question. I have toured your facility, and it's very impressive. And one of the things that impressed me, and I'm wondering if you could confirm this, I believe that when you're counseling women, you counsel them on all 3 legal options in the state of New Hampshire. Is that true?
That's correct. We do that. And if they choose abortion, they are welcome to come back. We do have clients that do choose abortion, and they come back to us, and we welcome them. Again, without judgment, without coercion, without shame. We're just there to help them.
Other questions? Seeing none, thank you very much.
Thank
Next, I'm going to call on Jean Marie Davis, please.
Good morning. My name is Jean Marie Davis. I am a survivor of sex trafficking. I was sex trafficked from the age of 2 to 29. I was born and raised in California. My family is the one that trafficked me. I was at 29 running for my life when the police in California told me I had to leave because I would be murdered by gangs, traffickers, and other people. They sent me on a trip to New Hampshire. I remember the people from the safe house saying to them, if I get on the bus, then I'd be dead before I get to New Hampshire. I was 4.5 months pregnant. I ended up in Keene, New Hampshire 11 years ago, and I was wanting to commit abortion. I was hooked on the crystal meth and I was homeless. And they told me about a pregnancy center. They said that they believed in Jesus. I said I didn't care as long as they're willing to help me. So with that, they took me in, knowing my situation, knowing that I was struggling, and they told me everything about my child. They let me hear the heartbeat of my child, and at that moment, I wanted to keep my child. My son is 11. He's outside right now playing on the games while he's here. I say all that because 11 years later, I am now the executive director of Branches Family Resource Center in Brattleboro, Vermont. I'm also the executive director of Branches Family Resource Center in Greenfield, Massachusetts, that we just opened. And yes, the reason why we have this, that we come with you to this bill is because in March 29th of last year, I won the case versus Vermont because they decided to do a bill and turn it into a law that would target pregnancy centers, where they said that we couldn't even let a woman come into the pregnancy center and hand them a pregnancy test for them to administer themselves in a bathroom, because if they said that we were not being a medical clinic. At the time, I was not a medical clinic. I was going into becoming a medical clinic. And so for that, they said that I would have been fined $10,000. And then they said to me that I couldn't even offer information
I'm sorry,
to.
your time is up. Questions for this witness? Seeing none, thank you very much. Oh, I'm sorry, Representative Pettingill, I'm sorry.
Thank you. You are going to be fined for offering a pregnancy test that could be obtained over the counter. Am I?
Yes.
Oh, thank you very much.
Other questions for this witness? Seeing none, thank you. Next, Liz Neville, please.
Good morning. Thank you for allowing me to speak. My name is Liz Neville. I'm president and co-founder of a home for women, homeless women, called St. Gianna's Place. We're a non-profit home. Our moms come in usually pregnant with their young children. We've taken women literally off the streets. Some were living in tents, some were living in cars. I'd like to ask the committee to recommend HB 1416 as ought to pass. Why does the passage of this bill matter to St. Gianna's Place? It's not so much that it matters to us as much as it matters to the vulnerable women and their children that we serve. This legislation would protect St. Gianna's Place so that we can carry out our mission of offering transitional living to the mothers and children that would be homeless without us. We offer a safe, nurturing home for up to 2 years. We provide life skills training like budgeting, cooking, nutrition, parenting. We offer women an opportunity to get their GED, job training, and even college courses. We provide a new service recently, which is a car service, and we help them to get their licenses and give them donated cars. At St. Gianna's Place, we care deeply about each mother. We pour a lot of love, time into these moms, helping them to heal. We teach them about their God-given dignity. Mental health is a huge priority for these moms. We offer them counseling, outsourced in outside clinics. Excuse me. Women come to us abused, beaten down, oftentimes right out of rehab. The families they've come from are so broken. They've often been raised by addicted parents. But in time, we see these moms' lives transformed as their confidence is restored and they learn to love themselves and know that they matter. I'd like to read about what one of our residents.
I'm sorry, your time is up. Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Bob Dunn, please.
Good morning, Mr. Chair, members of the committee. I'm Bob Dunn, the Director of Public Policy for the Roman Catholic Diocese of Manchester. It's good to be back here. I'm here today on behalf of Bishop Peter Labashi to register our support for House Bill 1416. We think this is something that advances the fundamental principle of human dignity, the human dignity of both the mom and the child. And that is a question that is really important whenever we're thinking about abortion bills, because how we look at abortion resonates across the public policy spectrum. If we want society to value the young human being at the border, or the young human being who's homeless, or the young human being who needs shelter or food, then we need to value the human dignity of the young human being in the womb as well. Once we start asking society to treat certain ones of us as disposable, then we can't be surprised if society begins to treat certain ones of us as disposable. Lastly, I just would like to answer Representative Andrus's question, and others have asked the same question. I think the proactive nature of this is something that is not really unusual in the New Hampshire legislature. Suppose we could look back and find all sorts of times where this sort of activity was going on. They were trying to be proactive. But I also would add, and I think this is what Representative Farrington was referring to, you're not the only ones who legislate. The executive branch also legislates through the adoption of administrative rules. So a bill like this has an impact regardless of what happens with shifting majorities. So thank you very much.
Thank you. Questions for this witness? Seeing none, thank you very much. Next, Lorraine Lindenberg, please.
Morning, Mr. Chair.
Morning.
I'm Lorraine Lindenberg from Derry, New Hampshire. And the only thing that I wanted to talk about is in May of 2012, a House concurrent resolution 31 was passed by the House and the Senate to commend the pregnancy centers of New Hampshire and the United States. Why is this bill so important? It solidifies the pregnancy centers' rights to choose how they want to operate, just like any other business, without government interference. In the resolution, the pregnancy centers were commended for all the great work that they do. There are over 2,500 pregnancy centers in the United States that do individualized care to women, men facing planned and unplanned pregnancies. The pregnancy centers provide women with compassionate and confidential peer counseling in a non-judgmental manner, regardless of their pregnancy outcomes. They also counsel women who have made choices of abortions and to help them through the trauma of healing from that. They also counsel families for how to talk to their teens about wise sexual choices. I support HB 1416, and I hope all of you will too.
Thank you very much. Questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Beth Scarra, please.
Beth Scare, Nashua. I'm here in support of this bill. If you read online reviews for pregnancy centers and the testimony against this bill, you will see two starkly different pictures of pregnancy centers. Those who oppose pregnancy centers will say they are hurting vulnerable women, but they're basing their opinions on rumors. They haven't actually visited a pregnancy center. They haven't talked to anyone who's used the services of a pregnancy center. In these negative reviews and in testimony against this bill, you will see a lot of anti-Christian bias. Many of those who submitted testimony against this bill work for abortion facilities, including at least one abortionist. So they have a financial interest in stopping pregnancy centers from helping women. A lot of the opposition to pregnancy centers is rooted in eugenics. The opponents don't want women who are poor, drug addicted, rejected by their partner or family, or undocumented to give birth. When you read the positive reviews, you'll hear stories from vulnerable women who are in desperate situations who found love and acceptance and material help at pregnancy centers. They described how they were down in their luck and the pregnancy centers were there to provide compassionate care. This is a pro-liberty bill. It gives pregnancy centers the right to provide the services to help pregnant women in need and their babies without the government putting a boot on their necks and forcing them to do things they don't believe in. This bill is very much needed in the live free or die state. Please vote ought to pass.
Thank you. Questions for this witness? Seeing none, thank you very much. Next, Michael Eunice, please.
Thank you, Mr. Chairman, members of the committee. My name is Michael Eunice. I'm a resident of Rochester. I'm also the Executive Director of Options for Women, a medical pregnancy center located in Rochester, where we've been serving the Seacoast community for 42 years. Pregnancy centers exist to provide practical, emotional, medical, and educational support to women and families facing pregnancy decisions. At Options, that includes pregnancy testing, ultrasound exams, limited STI testing and treatment, services which are provided by our medical services team, a team of 3 RNs and 2 RDMSs, registered diagnostic medical sonographers, each one of them carrying licenses issued by the state of New Hampshire. In addition, parenting education, referrals to healthcare and community services are also offered, as well as material assistance, which includes things you've heard about: diapers, baby wipes, clothing, sometimes gift cards, which are made available to us, which often are the difference between a family having food on the table and not having food on the table. At its core, this bill affirms a principle long recognized by healthcare, nonprofit service organizations, and that is providers work within defined scopes of care, such as hospitals, specialty clinics, counseling agencies, and other nonprofits that are serving the public best when they are allowed to function with clarity of purpose and organizational integrity. Many of the women who come to us are navigating difficult situations: financial instability, housing uncertainty, relational stress, and a lack of support systems. What we often hear from them is what they value most: help from people who will walk alongside of them without cost, pressure, or judgment. This bill does not limit access to any medical service currently available in our state. Rather, it preserves a diverse network of providers so that women can seek support that aligns with their individual desires and values. With pregnancy centers
Thank
being
you
an
very much,
important...
sir. Yeah, I'm sorry, but your time
That's
is up.
okay.
All right.
It's all right, I understand.
All right. Questions for this witness? Seeing none, thank you very much. Next, Rachel Potter, please.
Good morning, Mr. Chair and honorable members of the committee. For the record, my name is Rachel Potter, and I serve as Policy Associate at the ACLU of New Hampshire. I'm here today to oppose this bill because, like similar legislation that's being filed in other states, it would elevate institutional ideology over individual rights and medical accuracy. So we are concerned that this bill would grant special statutory privilege to crisis pregnancy centers, organizations that are expressly mission-driven and structured to promote a specific anti-abortion viewpoint, while exempting them from the kinds of oversight that apply to hospitals, clinics, and other health-related providers. HB 1416 would carve out special protections for these crisis pregnancy centers, shielding them from transparency and accountability standards that apply to health and social service providers, effectively creating a separate and more favorable set of rules for organizations advancing a particular viewpoint. And we believe that no organization should be entitled to an exceptional legal status simply because of an ideological position, and equal protection under the law demands that all health service providers engaging with the public be held to consistent standards of truthful, transparent conduct. So allowing exemptions from healthcare standards based solely on ideology sets a concerning precedent, and so we ask that you vote ITL in this bill.
Thank you. Questions for this witness? Seeing none, thank you very much. Next, Attorney Ian Hewitt, please.
Mr. Chair and members of the committee, Ian Hewitt for Cornerstone in support of 1416. This is maybe the most modest, least ambitious bill in some ways that certainly I've testified on. It just says you can't de facto or indirectly ban pregnancy resource centers. Nonetheless, we think PRCs in New Hampshire could very quickly become vulnerable to the violations that are prohibited in this law. Representative Farrington mentioned he's concerned about what could happen under agencies in a future administration. I'm maybe less sanguine about our current state agencies. We believe that many of our state agencies are partisan and that there is a pattern of them getting far ahead of or acting contrary to state statute, unless there is a judicially enforceable statutory remedy like would be created by this bill. And then if there was a facially neutral state agency action targeting a PRC, we think whether we could get constitutional relief may be questionable. Certainly the First Circuit Court of Appeals is more likely than any other Circuit Court of Appeals to say controversial speech is harmful in some way that places it outside the scope of First Amendment protections. The only other thing I'll say is if someone, let's say, introduced a bill saying the state shall never compel anyone to attend church, I would think that bill was kind of silly and pointless, but we wouldn't show up here and oppose it because we have no intention of ever trying to compel anyone to attend church. I think the reason that the Medical Association, the ACLU, Planned Parenthood are here in opposition to this bill is that they would in fact like to use state agencies to go after PRCs. I'd be happy to take any questions.
Questions for this witness? Yes, Representative McFarland.
Thank you, Mr. Chairman, and I think the point that Ian just made at the end there is very compelling. To that point, I would like to ask you, to what extent have we seen that kind of action by those kinds of groups in other states?
Well, the biggest campaign has been in Massachusetts, and Representative Farrington mentioned it. And probably the kind of most directly First Amendment type enforcement action we've seen from Massachusetts is state agencies using open-ended investigations to cause financial strain to PRCs. So they're not coming right out and saying we're going to formally prohibit you from providing these services, but we're just going to cause you to incur costs by doing these open-ended investigations. And for that reason, we support the bill in its current form, but it might be a good idea to page 2, lines 5 through 6, after the word shall not, through and then onto the rest of the line on line 6 to remove those words. And that's because the injuries sought to be prevented on lines 7 through 29 really are the things that should give standing to a PRC to bring a lawsuit. And it could cause some confusion around standing if it seems like the injury conferring standing is the promulgation of a regulation instead of the injuries sought to be prevented on 7 through 29.
Other questions for this witness? Seeing none, thank you very
Thank you.
much. Next, Elise Sherian, please.
Good morning, House Judiciary Committee. My name is Elise, and I'm a New Hampshire resident, and I'm here to testify in opposition to HB 1416. I want to start by saying that pregnancy resource centers sound great and that there is a big need for people, parents, and families to have more support, especially relating to diaper and baby formula access. But what is different here is that these pregnancy resource centers are often faith-based and informed by religious beliefs. While this is not inherently bad, though it violates the separation between church and state, they are steering people away from safe and legal options, such as abortion, which is a safe and legal option in New Hampshire, regardless of personal views on it. Additionally, pregnancy resource centers, as described in this bill, provide inaccurate information on the safety and access to abortion, as well as inaccurate information on prenatal development. I've done extensive research on this topic, and these centers are often non-medical and faith-based, meaning that the staff may not be medical providers, and ultrasounds that are conducted are often done by non-medical staff members. One of the dangers I want to point out is that while non-medical ultrasounds can detect whether someone is pregnant or not, they cannot detect fetal abnormalities, which can pose an extreme danger to the pregnant person. Since these are not medical centers, they are not required to follow HIPAA guidelines. While some senators said they do follow HIPAA, there is no legality binding them to these privacy guidelines. Moreover, research has shown that pregnancy resource centers have a history and tendency of deceiving patients by telling them that they are further along in pregnancy than they actually are, which can affect how someone perceives their pregnancy options. Providing inaccurate information on abortion and prenatal development can give the impression that abortion is not safe, or that fetuses develop at a more rapid pace than medical science has proven. Sharing information that has been medically unfounded creates the perception that there are fewer options than are actually available. If someone goes to a pregnancy resource center and decides that they want an abortion, these centers do not provide people with any referrals or information on how to access abortion, despite it being a safe and legal option in the state. New Hampshire should prioritize supporting and protecting health
Your
centers,
time is up, ma'am. Thank you.
and I will not be taking any questions.
All right, thank you. Next, Liz Canada, please.
Good morning. For the record, my name is Liz Canada. I'm the Advocacy Director, Planned Parenthood Northern New England, Planned Parenthood New Hampshire Action Fund. Planned Parenthood has been mentioned a few times today, even though this bill doesn't have anything to do with Planned Parenthood. What I've heard from a few folks beforehand is about hypothetical attacks, hypothetical legislation, hypothetical things that could happen in the future by a future administration or by future lawmakers. That's all hypothetical. What is actually happening and what has happened is in 2022, the US Supreme Court overturned Roe v. Wade. That is a real attack. That actually happened. Multiple times, legislation has come before this committee and other committees to enshrine and protect the right to abortion. That hasn't happened yet in New Hampshire. New Hampshire remains the only state in New England that does not have explicit protections for abortion. So I'm here in opposition to House Bill 1416 because this is about protecting and shielding private entities with a very specific ideological belief, agenda, and that's against what the legislature would want to have happen, I imagine, is that you should be able to have a private entity exist as it needs to, but that's not what needs to happen in law. There are not actual attacks on these entities. So thank you for your time.
Questions for this witness? Representative Birch.
Thank you, Mr. Chair. Thank you for taking my question. Since I gather in your real life job, you kind of keep track of these things. And given that we are not Vermont, where I lived for many years, and we are not Massachusetts, most emphatically.
That's my understanding.
And given the earlier testimony that the legislature had passed a concurrent resolution some time ago in support of pregnancy resource centers as an institution. My question to you is, are you aware of any in real life legislative or other current attacks on the existence of pregnancy resource centers in New Hampshire? Or is this simply this bill simply a solution looking for a problem?
Thank you for the question. There have been no attacks on legislation or in any way on these private entities. They are welcome to do as they wish.
Thank you.
Other questions for this witness? Seeing none, thank you very
Thank you.
much. I don't have any other cards. Is there anyone else who wishes to be heard on HB 1416? Yes. I'm going to ask you to please fill out a card.
Thank you, Mr. Chair. Thank you, Mr. Chair. My name is Jason Hennessy, and I am honored to be serving as the president of New Hampshire Right to Life. I'm going to talk about three things today. Whether pregnancy centers provide a necessary service, the attacks that they've seen in other states, and why we need this bill to protect them here. So first off, pregnancy centers provide a necessary service to hundreds of women a year. And if you believe in choice, then you'll agree that that they're doing good work and they need to continue doing that good work because the choice of life is one of those choices. Pregnancy centers have been attacked in other states, and the chairman asked about executive branch attacks. The testimony I'm passing out is from AUL, and they have documented many different attacks in states like California, New York, and Massachusetts, and other ones where the attorney generals are going after the pregnancy centers. Another one I'll point out is EMTALA from the Biden administration, where they tried to force the doctors to perform abortions using an executive branch tactic. And then at the Supreme Court, they said they weren't. But the other one I'll point out is in Massachusetts, which you've heard about. One of the things that happened there was the DHHS and the Attorney General both sending out intimidating letters. They also were attacking abortion pill reversal, which I'll just point out. The other side says they don't want to get between a doctor and their patient, but it seems like the attacks on APR are doing exactly that. If you're interested in the science, check out aprscience.org, which has all sorts of studies. I've heard no examples of actual deceptive practices or other negative things that have happened. They're theoretical. Finally, there are 19 pregnancy centers here in New Hampshire. These protections are not generic. They are very, very specific based on what we've seen all across the country. There is a national playbook.
Thank you very much, sir. Your time's up. Are there questions for this witness? Representative Manos.
Thank you, Mr. Chair, and thank you, Mr. Hennessy, for taking my question. The document you provided us is quite lengthy, but I don't see any mention of New Hampshire in here, and I'm wondering whether there have been any attacks in New Hampshire legislatively on crisis pregnancy centers.
Thank you so much for the question, Representative. I'll mention that one pregnancy center was vandalized and physically attacked in Littleton, New Hampshire. As far as I am aware, that has not been resolved. Also, two of the top ticket Democrats, the governor in 2024, the governor and a congresswoman, both documented their desire to go after pregnancy centers. So this is not just a theoretical, this is a very real concern.
Follow up?
Have there been any legislative attacks?
Not that I'm aware of.
Other questions? Seeing none, thank you. I guess I have one. Oh, I'm sorry, Mr. Scully, Representative Scully, sorry.
Well, no, thank you. I appreciate it. Good day, and thank you for coming before us. You had mentioned that there seems to be an organized series of attacks on these types of pregnancy centers across the nation. Could you just please expand a little bit more on that? Because would like to try to defend against patterns that could happen here.
Sure, thank you for the question, Representative. So in Massachusetts, I think those are the closest to home, where the Department of Health and Human Services and the Attorney General sent out letters, well, at least DHHS sent out letters to the doctors saying that, warning them that deceptive practices can result in the loss of their license. They also sent out letters saying that abortion pill reversal is not standard of care. And while these are not, we're going to shut you down kind of things, they are intimidating because a lot of these pregnancy centers, they run on shoestring budgets with volunteers. And a lot of times the medical directors aren't even paid. So if you're getting a letter saying you could lose your license, that is very real intimidation. This legislation would help to protect that because, I mean, first off, it's against the First Amendment anyway to be doing this kind of viewpoint discrimination. But secondly, it would give them a legislative defense that would just that would save them a lot of money and time.
Other questions? Seeing none, thank you very much.
Thank you.
Kathy Stratton, please. Oh, and can I, yes, sir, can I ask you to fill out a pink card, please?
Good morning, and thank you for taking my testimony today. My name is Kathy Stratton. I'm the CEO of the New Hampshire Medical Society, and I'm here to speak in opposition to HB 1416. In talking with physicians about this bill, there's a broad concern that women coming to these centers for medical care are not seeing medical personnel, and this could result in misdiagnosis, delayed diagnosis, and patient harm. The bill prohibits regulation regarding the pregnancy resource centers, and we believe that their misrepresentation to patients in certain instances, not representing themselves as faith-based organizations, could lead to informed consent that really isn't appropriate. And we feel that that's the basis of good care for patients. This is virtually an unregulated industry. The pregnancy resource centers seek to provide care for pregnant women. We value the care that they provide, but exempting these organizations in this fashion fails to protect patients and women from medical harm and patient advocacy regulations. So we request that you vote ITL on this bill.
Questions for this witness? Representative Petternell.
Thank you, Mr. Chair, and thank you for taking my question. Do you have any proof that medical care is like complete obstetric medical care is being provided at these centers, or are these women being referred to medical professionals to deliver their babies? I'm pretty sure the pregnancy care centers do not deliver babies there, so I'm not sure what medical care you're assuming they are not receiving or are receiving in these facilities.
We're referring to proper ultrasounds that might diagnose ectopic pregnancies or early fetal anomalies, things that could be cared for early on with medical diagnosis and diagnostic care.
Yes, thank you. So are you assuming that they provide prenatal care, or do you know for a fact that they provide prenatal care? Because I've took the tour of 8 pregnancy care centers and not one of them provides prenatal care. They refer to physicians for prenatal care. So can you tell me what you are basing your assumptions on?
Our assumptions are based on the fact that they are advertising ultrasounds, pregnancy tests, and other care that could delay patients from receiving care in the physician or advanced practice nurse or physician associate office.
Other questions for this witness? Representative Birch.
Just a quick question. I don't know if you heard the testimony from the prior witness. He made reference, if I heard it correctly, that the state of Massachusetts was seeking to inform or regulate around doctors who violated their medical licensing requirements, and that the state was going to take action if they did so. Is that a problem as you see it? If the state basically tells doctors, do what your licensing says or you might be in trouble?
I mean, I think that we have appointed people on peer review medical board that's appointed and non-biased to review these questions and these issues. I trust their judgment and the due diligence that they put into every complaint or issue that's brought to their attention.
Other questions for this witness? Representative Page.
Thank you. Really, very briefly. Is it possible that someone walking into one of these centers and seeing medical equipment, things like that, like a ultrasound or whatever, could be given the perception that they're getting medical advice?
I think that's possible. I mean, our concerns are that what we're talking about today removes oversight from these centers, and I think it's a business. It's providing what's healthcare adjacent, and it should not be exempt from regulation.
Other questions for this witness? Seeing none, whoops, Representative Horgan.
Yes, alluding back to the situation in Massachusetts, we heard about, part of the a previous witness seemed to imply that it was inappropriate to apply the same standards of medical care to work that's being done on a volunteer basis if that was being paid for. But so do your members, are they held to the same standards regardless of whether or not they're being directly paid for providing the service that they're providing? So does that apply, like, regardless of what the financial arrangements are for providing the service?
I'm a little confused. Can you rephrase that?
I'm sorry.
Thank you.
Well, we had the issue of, this issue of whether or not certain care was appropriate in Massachusetts, and one of the things we heard, I guess it's not in our state, it's a different state, but like supposedly that the doctors providing the volunteer service solely to apply. One of the reasons why it's inappropriate is because these doctors were volunteers, so we shouldn't get too fussy about whether or not the care they're providing is appropriate. But I guess your members, I hopefully they do follow the same ethical and medical standards regardless of whether or not they're being paid for providing the service. That's what I meant.
Certainly a patient, whether they're getting a voluntary service or a paid for service, whether it's by your health insurance or private pay, I mean, you're deserving of the same standard of care.
Other questions for this witness? Seeing none, thank you very much.
Thank you very much.
Now I think I do not have any further cards on HB 1416. Is there anyone else who wishes to be heard? Seeing none, I'm going to close the hearing on HB 1416, and I'm going to open the hearing on HB 1456, repealing the legislature's declaration of authority over public education. Is there anyone? Okay. Yes, if you'd hand it to me, that'd be fine. Thank you. Great. Terrific. Thank you.
Any mistakes in my written
All right. So you just pass those down, and you just pass those down. Thank you. Okay. A whole bunch. This is on the previous bill. All right. Yes, please.
Thank you, Mr. Chair. Member, I'm State Representative John Cloutier from Sullivan County District 6, which comprises the communities of Croydon and Claremont. And I'm here today as the prime sponsor and strongly in favor of House Bill 1456, which would repeal the legislature's declaration of authority over public education at the expense of the judicial branch. A declaration inserted into the trailer bill, House Bill 2, last year. Now, why should this declaration of authority, a declaration basically of sole authority, be repealed, in my opinion? First, I believe this declaration of sole authority interferes with a separation of powers doctrine in the New Hampshire Constitution among the three branches of government, the executive, legislature, and judiciary, but especially between the legislature and the judiciary when it comes to funding public education. Especially public K through 12 public education. Obviously, the legislature can regulate public education through rules developed by State Board of Education. Sorry. Okay, yes. I'm sorry about that interruption. Public education, including the funding of education, and the State Board of Education and the New Hampshire Public Education, obviously can regulate public education through rules such as the number of days public schools can be open, the type of curriculum to be taught, and the minimum qualifications for teachers, administrators, and other staff. among other topics. However, I firmly believe that it is the duty of the judicial branch, including the state Supreme Court and the lower courts, to determine if the laws and rules pertaining to public education, including its funding, violate the articles of the New Hampshire Constitution. And in 1993 and 1997, a majority of the Supreme Court ruled the way we fund public education with its over-reliance on local property taxes was unconstitutional. And more specifically, in 1993, the majority of justices declared that this education funding system violated Part 2, Article 3 of the Constitution, which guarantees students a right to public education. And in 1997, the justices ruled that local property taxes, as levied at the time, violated Part 2, Article 5, which declared that all taxes levied for state services like public education be proportionate and reasonable. And while I believe in the immediate aftermath of both the 1993 and 1997 decisions, we in the legislature, and I've been in since 92, so I think I have a little experience, for better or for worse. We tried to fund an adequate education. We were simply unable to craft an adequate education funding system that was permanent, to my regret. Nevertheless, the rulings of both the 1993 and 1997 education funding decisions have been upheld in recent years by subsequent Supreme Court and lower court rulings to this date. However, and we pushed back too. Since 1993 and 97, numerous amendments to the state constitution have been introduced to overturn the Supreme Court decision, which is our right. By my rough estimate, and I did some research working with the Office of Legislative Services, there have been at least, and I'm being conservative, at least 32 proposed amendments considered by the legislature since 1993 to overturn the Claremont decisions. None of them have obtained the required 60% majority in either the House or Senate to be forwarded to the voters, who would then have to ratify them by a 2/3 supermajority in order to become constitutional. So we tried to push back. We just haven't been successful. Finally, Mr. Chairman, the reason I think I introduced members of the committee over the past year, I have communicated with many constituents and Sullivan County residents over this issue. They state, and this goes back to, and this is not just in Claremont, not as a result of what has been happening in Claremont, which many of you are aware of. This has been happening in Newport, Unity, other communities, especially in Sullivan County. Croydon, they are angry at the way that public schools are funded in our state. An unfair system that they claim reduces the quality of their students' education and puts an enormous burden on property taxpayers who are the least able to pay. Some of these citizens that I've listened to in public meetings are so angry that they have declaimed that we as legislators, as well as recent governors, including the present governor, ought to pay fines or even go to jail for what they claim is inaction on school funding. When I first heard this at a meeting in Newport a year ago, I was frankly put on the defensive, because I know we've tried. But nevertheless, I tried to listen to their anger. I can understand it. And this anger bubbled up again in August when the whole Claremont issue came up. And people are angry at the Claremont School Board, the people they hired, and legitimately so. But they're also angry at the state and the fund, which they believe played a part in this whole fiasco in Claremont. In summation, I agree with their anger. I believe it's time to do our job by fully funding an adequate education, no matter how difficult the task. And I know how difficult it's been. We can begin by giving House Bill 1456 a positive recommendation. Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much.
All right. Thank you, Mr. Chairman, members of the committee.
Is there anyone else who wishes to be heard on House Bill 1456? Seeing none, I'm going to close the hearing on House Bill 1456, and I'm going to turn the chair over to Vice Chair Mannion, because I will be introducing the next bill.
Thank you, Mr. Chair. I'm going to now open the public hearing on House Bill 1489, and I recognize Representative Bob Lynn to introduce this bill.
Thank you, Mr. Chair, and members of the committee. I appear here in support of House Bill 1489. And as I would like also to, for the members, for the purpose of the committee, to recognize another person who's here, retired Professor Chuck Mooney from University of Pennsylvania Law School, who is one of New Hampshire's commissioners on the Commission of on Uniform State Laws, who I worked with extensively on this bill, and also House Bill 1127, which is one we may be execing during the day today. And I very much appreciate his expertise and his thoughtful assistance. We really, I think in New Hampshire, are very lucky to have his expertise and his willingness to serve on this commission. At any rate, this bill really is designed, as you can see by the sponsorship, I hope it's a nonpartisan bill. Myself and Representative Birch are the co-sponsors. It is designed essentially to streamline the process for getting discovery in civil cases, to eliminate the system of being required to get a commissioner to conduct depositions where there's an interstate aspect to the case, where you're trying to get discovery from witnesses in another state, or people in another state are trying to get discovery here. It basically sets out pretty sort of standard provisions specifying how the discovery process will work, saying that if there's a foreign, just as an example, if a foreign, let's say Massachusetts, wants to conduct a deposition of some person in New Hampshire, they can have a subpoena from Massachusetts would be issued. It would be delivered to the clerk of the Superior Court in New Hampshire. The clerk then here would simply issue a New Hampshire subpoena, and the same kind of rules would apply. That would apply if this was a New Hampshire case. So I don't think it's particularly complicated or controversial. I'm happy to answer any questions, and if something is beyond my ken, I'm sure that Professor Mooney would be willing to offer his expertise. With that, I'll take questions.
Are there any questions of this witness? No? Seeing none, thank you. James Scully? Just push the button.
Thank you. Good morning, Chair and members of the committee. My name is James Scully. I am the other commissioner on the Uniform Law Commission representing the state of New Hampshire. I was recently nominated by Governor Ayotte and appointed by the Executive Council. So any questions I will also be directing to Professor Mooney for his expertise, but I am also here on behalf of the commission, so thank you for having me. My name is James Scully. As I said, I'm also here on behalf of the Uniform Law Commission. The ULC is a nonpartisan, nonprofit organization founded in 1892, composed of practicing lawyers, judges, legislators, and law professors from every 50 states. Our mission is to draft well-conceived nonpartisan legislation in areas where uniformity across states is beneficial, such as the Uniform Commercial Code, and relevant today, the Uniform Interstate Depositions and Discovery Act, or the UIDDA. House Bill 1489 would enact the UIDDA in New Hampshire, modernizing and streamlining the process for conducting out-of-state depositions and discovery. Under current law, parties seeking discovery from New Hampshire residents in out-of-state litigation must navigate a patchwork of procedures, requiring the appointment of deposition commissioners, and additional court involvement, which adds unnecessary cost and delay. This act replaces with a simple, efficient process. A party seeking discovery submits a subpoena from the trial state to the clerk of the Superior Court in New Hampshire County where discovery is sought. The clerk then would promptly issue a New Hampshire subpoena for service, incorporating the terms of the original subpoena and listing all counsel and unrepresented parties.
This is simply a ministerial act, no need for judicial involvement, thus streamlining the process. Service, compliance, and any motions to enforce or quash are governed by New Hampshire law, ensuring that our courts retain control and that our residents are protected, which is important. This bill also repeals outdated statutes on the appointed and powers of the deposition commissioners, further simplifying the law. The UIDDA has widely been adopted across the country in 47 states, bringing uniformity, efficiency, and fairness. I believe the other states are all contemplating this right now, so it's likely that it will be adopted in all 50 states, including the District of Columbia, Puerto Rico, and the U.S. Virgin Islands. In summary, adopting the UIDDA through HB 1489 will make New Hampshire's legal system more accessible and efficient for all parties involved in interstate litigation. I urge the committee to pass this. I will now answer any questions or pass them off to Professor Mooney.
Thank you. Any questions? Representative Manos?
Thank you. Thank you, Attorney Scully, for taking my question. I'm just wondering, we have the current RSA 517A, which this would replace. And I'm wondering, from the commissioner's point of view, what is inadequate about our current RSA in this area? Thank you.
Absolutely. I don't have reference to that specific RSA representative, but what I can say is that what the commission is trying to do is streamline the process and make it more efficient across state boundaries. So should, like Representative Lynn mentioned, should someone want to do that, it's less encumbrance on the courts to appoint a commissioner and then do a deposition. It would be effectively the same as if a New Hampshire party was seeking to do a subpoena on another New Hampshire party. And so that way it streamlines the process and avoids the necessity for appointing a commissioner to go out and do a deposition. It essentially streamlines the process.
Any other questions? Seeing none, thank you very much.
Thank you, ladies and gentlemen.
I believe that Professor Mooney did not turn a pink card in on purpose. So is there anyone else who wants to be heard on House Bill 1489? Seeing none, I'm going to close the hearing on House Bill 1489 and turn it back over to Chairman Lynn.
Thank you, Representative Manning. I'm now going to open the hearing on House Bill 1550. And the chair, do we have a?
David Love.
We have, yes, Representative Love. You can offer your testimony first and then just.
Parliamentary inquiry.
Yes.
Mr. Speaker, I understand that Representative Love wants to basically do a replace all amendment. Is he allowed to do that and speak to the amendment?
He has a replace all. Sure, I guess. I mean, I'm not sure whether what the committee will do with the amendment, but certainly he can talk about it. Yes.
All right. Thank you.
Thank you, Mr. Chair. Thank you, committee members. For the record, my name is Representative David Love. I represent Derry, and I sit on the Children and Family Law Committee. And what this bill will do is have the justices, the mediators, whatever name that we put on these people that are helping to adjudicate divorces and family court matters, give them the power to ask for oath, the oath of truth, it doesn't exist right now. It's never done, and I won't say never, but it's rarely done in family court. And I think every one of us expect when we go into a court that they're going to seek the truth and they're going to make the judgment on that truth. And this will give the judges it'll make their job a whole lot easier. They won't have to be sitting there deciphering who's telling the truth and who isn't, and what was true, what wasn't. That they'll have to take an oath, and in perjury charges, it says the perjury charges shall be turned over to a prosecutor if the judge feels that there's a problem there.
I assume he's talking about
the amendment.
The amendment.
Yeah.
May I? Yeah. So we have it's when we just it's a little bit difficult when we don't have the amendment.
Yeah. Okay. I'm sorry.
So
I'll let you read that. I'll take a 3-minute break.
So your amendment still talks about I'm sorry, I should pass it down. Your amendment, if I understand it, still talks about, the people that are covered by the bill having to get, to be certified as a justice of the peace, is that correct?
Yes, yes.
Okay.
The purpose of that is if they're not certified as a justice of the peace, they have no more right to administer an oath than I do. Okay,
So it's your understanding that judges and marital masters, et cetera, have no authority to issue?
some of them don't,
Oh,
is what I've been
okay.
informed of. And, if we do it and then have them administer these oaths, then perjury charges can be brought. Unfortunately, in divorce proceedings, by the time they get to court, the two parties hate each other and they're out for blood and the kids pay the price. Kids always pay the price. And, this is just be another tool in the court's toolbox to stop some of that. And, once two or three are prosecuted, a lot of these lies will stop. And, that's, like I said, I sit on that committee and some of the stuff is heartbreaking that you hear. And, we have an opportunity to maybe put a stop to some of it. I'll take questions.
Question for this witness? Yes, Representative Ward.
I'm still still not sure how what you changed from the original bill. I noticed one thing that jumps way out and is that marital masters are no longer listed. And is that because, notwithstanding the fact that there's still some law about marital masters, there aren't any actual marital masters serving and probably not much possibility of more being appointed? Is that why you did it, or there's some other reason?
In case somebody decided that they wanted to appoint another one, that hasn't been struck from statute, I don't believe. So,
Your original bill mentioned the original bill mentioned the marital masters, and they don't seem to be listed here. So.
Oh, they are.
Where? Okay. Sorry. Okay. My apologies. But.
All right.
Yeah, somewhere.
Representative Smith.
Thank you. Thank you very much, Representative Love, for bringing this to us. And obviously, we haven't had a chance to analyze the changes that you proposed. Could I just ask you a couple of questions about that, if the chair permits? In terms of requiring everyone to be commissioned as a justice of the peace, do you, in this amendment, in any way change anything about how justices of the peace are approved? I mean, for example, justices of the peace have a very short time limit, like 5 years.
Mm-hmm.
They'd have to go back to the governor and executive council every 5 years.
Yes.
Has that changed at all?
No, that's all the same. The thing about that is, we need them to have that justice of the peace designation, I guess you'd call it, in order to administer oaths. So every 5 years, as it is today, without this bill, certainly seems reasonable.
Do you see any change in terms of the responsibilities of the executive branch versus the responsibilities of the judicial branch in the changes that you've made in this amendment?
No, I don't see any. The amendment from compared to the original bill, more or less what was put in there is mandating the perjury charges and referring them to for prosecution is what the changes were. But maybe a little bit different language. He did rewrite it. I just got this a half hour ago. But
all right, I'll stop it then.
Other questions for this witness? Representative Manos.
Thank you, Mr. Chair. Thank you for taking my question. Your original bill is an FN and it has a fiscal note attached. And I don't see a fiscal note attached to your amendment. Was one done And/or do you have any reason to believe that it would be different than the FN for the fiscal analysis for the original bill?
Yeah, I'm not sure, but I have no reason to believe it'd be any different than what was in the original bill.
All right, any other questions for this? Yes, Representative Birch.
Thank you, Mr. Chair. Thank you, Representative.
Thank you.
So, I have to say I'm somewhat confused about how these two parts interplay, but let me ask, the process that the bill is amended would have is that all those parties, mediators, arbitrators, neutral parties, et cetera, who are currently in would have to become justices of the peace by January, or they're out. Is that correct?
Yeah, that'd probably be, I didn't look at it that way, but yes, I'd imagine that'd be it.
And if I could follow up,
Yes.
what this means would be for current individuals in those positions, since becoming a justice of the peace requires, as I understand it, approval of the governor and the executive council. This would be a way to remove any current mediator, arbitrator, or neutral parties simply by the executive branch deciding you're out of here by not doing the justice of the peace approval.
I didn't think of that. I don't know, what we could do to alleviate, maybe grandfather them in, and do another amendment to grandfather them in. I'd be open to that.
Other questions for this witness? Representative Hort.
Oh, my apologies to committee and the court. I did misread the amendment. It's not actually replace all amendment. It just replaces almost all of it. But my question is, and maybe we've already answered this. So right now the effective date is January 1st, 2027. So if we pass either this bill, either without an amendment, with all those individuals are covered, which does include the marital masters, if any. They all have to get their justice of the peace in by January 1st, 2027, or is there some timeline for them to go through all the steps needed to become a justice of the peace?
Like I just answered Representative Birch, if we want to do, if you guys want to do an amendment to grandfather them all in, I'm great with that.
Other questions for this witness? Representative Birch.
Thank you. Thank you again, Representative. In your amendment, you talk about these individuals, not the witnesses, but the individuals, justice of peace, mediators, arbitrators, and neutral parties. They take an oath, and it says an individual who violates said oath shall be forthwith dismissed from their position as a justice of the peace, and presumably from their other, because they have to be a justice of the peace. So my question to you is, who determines whether the justice of the peace, mediator, arbitrators, or neutral parties violated the oath? And what's the process involving with forthwith dismissed? What due process goes on? Is this an impeachment? Is this, how does this work in the bill?
I'm guessing that they'd go through just the same type of judicial review board hearing that a judge that made some egregious mistakes would have to go through. If somebody has broken their oath, that's a serious violation. If you're a judge and you're not doing truthful things and you're breaking the Constitution, it's a violation, and it should be looked at, by the proper review boards.
Thank you.
Thanks for the
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Lauren Warner, please. Oh, yes. And Representative Love, could I just ask you to fill out a card if you would, please?
Almost good afternoon, honorable members of the committee. My name is Lauren Warner, and I serve as Deputy General Counsel for the Judicial Branch. I submitted a written testimony and won't read it all to you. It's getting passed around as well. But just to note just a few potential unintended consequences from the proposed legislation. As you all are aware, RSA 455-A:1, as Justice of the Peace, it requires appointment by the governor and approval by the Executive Council. So essentially, this isn't a process that's currently done for mediators, arbitrators, judicial referees, marital masters. Imposing this executive branch commissioning requirement arguably could violate Part 1, Article 37 of the New Hampshire Constitution, separation of powers, as it interjects executive branch control into court personnel decisions. There's also the possible concern that this could potentially politicize this process of individuals who are supposed to be neutral and impartial, overseeing on some of the family division matters, serving as mediators, judicial referees, marital masters, and the like, having this potential politicize reappointment of these individuals is concerning and would arguably no longer comply with what the goal is to have these as neutral arbitrators. Additionally, the judicial branch could foresee a reduction in individuals interested in serving as mediators. In particular, these are typically members of the New Hampshire Bar that are volunteering their time or serving as mediators in this capacity, and going through a justice of the peace appointment can sometimes take time to be put in place. It places additional restrictions. There's a 5-year term limit on this. So there is the concern that potentially this could reduce the pool of individuals who are willing to serve in these roles, as well as then arguably, if we're looking at some more rural locations, you would likely have a reduction in individuals being willing to serve. There's also the possibility, due to the fact that it would require all individuals who are serving in these roles now upon the effective date to be imposed, as you noted, Representative Birch, to become Justice of the Peace. That would essentially eliminate this pool of individuals to oversee these matters currently until they were put in as a Justice of the Peace, which we have no control over the time frame. It would then delay cases. If someone is not reappointed or unwilling to serve because of the process they have to go through, there is the concern that we would have case delays as well. I would note judicial referees and marital masters, though there are currently no marital masters. We have any marital master that retires, that position is then converted to a judge. They have taken constitutional oaths already. That is it. And I haven't reviewed the amendment, so I don't necessarily can speak to that, but I believe Representative Manos, it was your question, the fiscal note. I wouldn't necessarily see a change, but it just potentially, if there are perjury charges and such, that could potentially increase the cost of the fiscal note, because then the judicial branch would arguably be providing counsel to the individuals if they were charged.
Questions for this witness? Yes, Representative McFarland and then Representative Birch.
Thank you, Mr. Chairman. Speaking as a Justice of the Peace, my recollection is that you are required, in order to be, in order to have the Governor and Executive Council consent, to have been a registered voter in the state for at least 3 years. Is that your understanding? And in light of that understanding, what do you think that would do to the population of these personnel today? Are they all resident within the state, and do they typically reside in the state prior to appointment?
So that is my understanding as to the requirement for being approved as a Justice of the Peace. I can't speak as to the registered voter status of those that serve. Certainly for mediators, there's the possibility for individuals who are that may live outside of New Hampshire, potentially Mass and Maine, who are also members of the New Hampshire Bar and practice in concurrent states, also may be willing to serve as a mediator in some cases. So I apologize, I can't speak as to the voter status.
Representative Birch?
Just a quick question about taking oaths. The administrators and mediators and arbitrators and all the others, do they take an oath already?
Not, I would say not a constitutional oath, but yes, an oath. Yeah, it wouldn't be one under the New Hampshire Constitution as prescribed in this bill.
Right, but
Yes.
it's an oath to do their job
Y-
without.
You are correct.
or whatever.
Yes.
Thank you.
Representative Horton?
What's your opinion about the effectiveness of the, well, what the effect of the, last thing about the effective date, because they're supposed to take effect January 1st, 2027, and this bill, if it passes in something like it's either this form or the amended form, it would have to go to the Senate, the governor have to sign it, so they would probably have less than 6 months be left before January 1st, 2027. So does that, the way you read it, does that mean all these individuals have to scramble around and get certified, go through the whole justice of the peace process between the day when the bill's signed and January 1st of next year? Or
Yes, I agree. I agree with that. How I read the bill, the effective date, it would place a significant time constraint in order to have anyone who currently serves or would wish to serve in these positions become justices of the peace prior to or on that date. Otherwise, that would cause significant. It would be those cases they're sitting on would have to be delayed or heard by others, and that would cause significant case delays.
Representative Scully?
Thank you, Mr. Chair. I actually have a quick question and a quick follow-up, I hope, if I may.
Okay, sure.
So in these trials in family court, can people testify without being put under oath?
I'm not aware of that. No, people testifying under oath. No.
I mean, so they can testify without being under oath?
No, they would. If they are testifying in a court case, they are testifying under oath.
Oh, all right, thank you. You answered my question.
All right. Other questions for this witness? Seeing none, thank you very much.
Thank you.
So I know it's lunchtime, but what I would like to do is take a brief recess to request a brief caucus among my troops, so to speak. And then I would, I assume that Representative Birch may wish to do the same thing. Just so people know kind of where I'm going, I would propose to, when we get back from this brief recess, to exec House Bill 1422 dealing with new trials in criminal cases, House Bill 1127 dealing with the Uniform Voidable Transactions Act, for which Professor Mooney is here still if we had any questions. He also worked, as I said, extensively on that and was extremely helpful. I would also propose to exec 1489, the Uniform Interstate Depositions and Discovery Act. I would also propose to exec 1550 and 1416 and 1456. But to be 1416, that's the Pregnancy Resource Center, and 1456, which was the repeal of the Declaration of Legislative Authority over Education. The one before. 1550, that's Representative Love's bill. So those are what I propose. Now, obviously, based upon what happens in my caucus and perhaps what happens in the Democratic caucus, that may change, but that would be my proposal. So let's take about 15 minutes.
So, we're going to do the execs immediately when we come
Yes.
back, or after we hear the other?
No, immediately. I'd like to do them immediately.
All right, before one.
Mr. Chair,
Yeah,
could I
yeah,
ask a
yeah.
very naive question? When we have a committees of conference between the House and the Senate, we clearly have two different groups. I like to think of this committee as the Judiciary Committee, and I don't really understand why we have to talk to the members of our own party before we decide how we're going to vote.
Well, I guess I would say because I want to make sure candidly where my party is, and
See, all right, thank you very much.
all right. So we'll be in recess for, about 15 minutes, all right? Thank you. Committee back to order, and I'm going to open an executive session first on House Bill 1489, that's the Uniform Interstate Deposition and Discovery Act, and I will recognize myself to make a motion of OTP. Is there a second?
I will second it.
All right, so it's moved by myself, Representative Lynn, seconded by Representative Birch. And the motion is OTP. I think I've fully discussed it in my testimony. I don't have anything else to say. Is there anyone else who wishes to be heard on House Bill 1489? All right, then I would ask the clerk to call the roll. The motion is ought to pass.
All right. Okay, so votes on OTP for 1489. Vice Chairman Mannion.
Yes.
Representative Nodder.
Yes.
Representative Tripp.
Yes.
Representative Andrus.
Yes.
Who's subbing for Kate? Who's here for Kate?
Oh,
Or she doesn't say.
Maybe it's you, Katie, maybe you.
You're for Paul.
Oh, you're here for Paul, so you must be here, yeah. All right.
Okay, so no vote for Kate.
No vote, right, that's right, because we are, that's right, that's right.
Down one.
No vote.
Okay, thank you. Sorry about that.
Yeah.
Absent. No vote. Okay, very good. Representative Mattson.
Yes.
Representative McFarland.
Yes.
Representative Scully.
Yes.
Representative Petronell.
Yes.
Representative Birch.
Yes.
Representative Smith.
Yes.
Representative Horrigan.
Yes.
Representative Page.
Yes.
Representative Manos.
Yes.
Clerk votes yes. Representative Long
Yes.
and Representative Bertrand.
Yes.
And yeah, sorry. and Mr. Chair.
Yes.
Yes. So that's
17.
15, 17 yeas, 0 nays.
Any objection to this going on consent? Seeing none, it'll go on consent, and I will write the report. All right, next, I'm going to close the executive session on 1489 and open the executive session on House Bill 1127, the Uniform Avoidable Transactions Act. And I will recognize again myself for an amendment, and I will offer amendment 2026 0880H. Is there a second?
Second.
All right, so it's moved by myself, seconded by Representative Mannion. And I'm just going to, yes.
You also moved OTP to start the conversation. And then moved the amendment.
I'm sorry, you're right. I move OTP, and then, and is there a second for that?
Second.
All right, second by Representative Mannion, and now I move the amendment 2026-0880H, and is there a second for the amendment?
Yes. Yeah, I second that.
All right, so both have been moved and seconded, and I'd like to speak to the amendment if I may. As you know, this bill is designed to replace what is currently known as the Uniform Fraudulent Conveyances Act, RSA Chapter 545A, with a new chapter, RSA 545B, which is known as the Uniform Voidable Transactions Act. And this is designed to have New Hampshire adopt the uniform law on these voidable transactions that is generally has been adopted in many states. One of the things you may recall when we had the hearing on this bill is that there was a concern expressed by representatives of the trust industry and the council in particular, that the language of the original bill could have some negative impacts on trust, on trust, and in particular, some type of irrevocable trusts that are now allowed under New Hampshire law, that have spendthrift provisions in certain cases. And one of the things that council were concerned about, and I think legitimately so, was, as you all may know, New Hampshire is trying to build up its reputation as being a sort of a center for trust law where people want to come and, establish their trust, et cetera. And so they were very concerned that we not inadvertently do something that would somehow undermine that. Again, I can't say enough about how much I appreciate the efforts of Professor Mooney here. He worked extensively with the trust representatives to come up with language that that addresses their concerns. And Amendment 2026-0880H reflects that a consensus that they've arrived at is reflected in this amendment. It is specifically what it does basically is to say that if there is a transfer of something of value that's made to one of the covered trusts, then certain things apply. One of which is that there would have to be, if there was a claim of fraud, of actual fraud, the proof would have to be by clear and convincing evidence rather than the standard that applies in other civil cases of proof by a preponderance of the evidence. And that really, oh, and the other thing is it makes some, the amendment also makes some cross-reference changes. Since 545A is being repealed and replaced by 545B, there are some places in which there are some references in other law to 545A that have to be changed. That's the essence of the changes. I think it's a good bill. The amendment alleviates the concern of the trust people, and I hope you'll support it. Anyone else wish to be heard on the amendment? Yes, Representative Manos.
Perhaps we could hear from the professor, but I'm not clear on why this just applies to an irrevocable trust. The amendment applies to an irrevocable trust and not a revocable trust.
Professor, or could you just elaborate for a moment, if you would, please?
Just push the button.
Thank you. Charles Mooney, Uniform Law Commissioner. The only trust with respect to which the Trust Council had expressed concern were the spendthrift trusts that basically protect the trust assets against creditors, and in particular, a transfer to the trust that could be set aside as fraudulent. And those are always irrevocable. And that's part of the idea. We've locked up these assets. So that's the reason why it's specifically limited to a specifically defined type of trust.
Other questions for this witness? All right, so then we're back to the vote on the amendment, and I wonder if anybody object if we do that on show of hands on the amendment? So I guess all those in favor of amendment 2026-0880H, please raise your hand. All right, anyone opposed? So the vote on the amendment is 17-0. All right. And we're now up on to the main motion of ought to pass as amended with amendment 2026-0880H. Anybody wish to be heard on that? Seeing none, I'd ask the clerk then to call the roll of OTPA on House Bill 1127.
Thanks. Vice Chairman Mannion,
Yes.
Representative Nodder,
Yes.
Representative Tripp,
Yes.
Representative Andrus.
Yes.
Clerk is absent. Representative Matson,
Yes.
Representative McFarland,
Yes.
Representative Scully,
Yes.
Representative Petronell,
Yes.
Representative Birch,
Yes.
Representative Smith,
Yes.
Representative Horrigan,
Yes.
Representative Page, Representative Manos.
Yes.
Clerk votes yes. Representative Long,
Yes.
Representative Bergeron.
Yes.
So, sorry. Chairman Lynn.
Yes.
17 yeas, 0 nays.
All right. Any objection to it being on consent? All right, it will be on consent. And again, Representative Birch, if you want to write the report on that, that's fine, but if you don't, I'll write the report. All right, I'll write the report. I will write the report.
Mr. Chair, was this also you made the OTPA and Mannion?
And Mannion seconded, right, yes. All right, next,
I second the
Yeah.
yes, consent, yes, I'm sorry. Next, I'm going to turn to House Bill 1422. And Chair recognizes Representative Birch for a motion.
Thank you, Mr. Chair. I move OTP.
I will second that motion, and I would like to introduce Amendment 20. I'll recognize myself for an amendment. I would like to introduce Amendment 2026-0871H. Is there a second?
I second the motion.
All right, that's seconded by Representative Andrus. And if I could speak briefly to this, the only thing that this amendment does is it adds in the second sentence of 526-4, Roman numeral 4, it adds the language, and if the petitioner is indigent, appoint counsel for the petitioner. The original bill could have been read to say that the court must appoint counsel whether somebody's indigent or not. That didn't make any sense, and I think the proponents of the bill also agreed that it didn't make any sense. That's the only change. So I hope you'll support the amendment. Other than that, it makes no changes at all. You may note I had suggested possibly, and actually I think Ms. Mossel even agreed, that we should change the language in the bill that says if the court doesn't find that a prima facie showing would be made, the petition, I suggested should we change may to shall, but I didn't include that in the amendment because frankly Representative McFarland made what I thought was a good argument to me that, look, if it's really a close case, shouldn't the judge have some discretion not to dismiss the case if it's that close? And I think that makes a valid point. So I left it with may. So that's the only change. The only change is dealing with the indigency. I hope you'll support the amendment. Anyone else wish to be heard on the amendment? Seeing none, can I just ask, can we do this by a show of hands again? So all those in favor of 2026 Amendment 0871H, please raise your hand. Anyone opposed? Seeing none, so the vote on the amendment is 17-0. And now we're back to Representative Birch's motion of OTPA.
That's right.
All right.
I so move.
So Representative Birch moves OTPA. I will second that. Representative Birch, if you wish, anything further you wish to say on your motion, on your bill? No. All right. So we're ready for a vote then on House Bill 1422. The motion is OTPA.
Vice Chairman Mannion,
Yes.
Representative Nodder,
Yes.
Representative Tripp,
Yes.
Representative Andrus,
Yes.
Representative Kutab is absent, Representative Mattson,
Yes.
Representative McFarland,
Yes.
Representative Scully,
Yes.
Representative Petronel,
Yes.
Representative Birch,
Yes.
Representative Smith,
Yes.
Representative Horrigan,
Yes.
Representative Page, Representative Manos,
Yes.
clerk votes yes, Representative Long,
Yes.
Representative Bergeron,
Yes.
and Chairman Lind.
Yes.
Yes. 17 yeas, 0 nays.
All right. Any objection to consent? Seeing none, it'll be on consent. Representative Birch, you draw the honors on this one. Okay.
Yep.
All right. All right, let's see. All right. So I'm going to close the hearing on House Bill 1422. And I'm going to open the hearing on, I'm sorry, I'm going to, oh, thank you. I'm going to open the executive session on House Bill 1550. And I will move ITL. Is there a second?
I second.
Moved by Representative Lynn, seconded by Representative Tripp. And let me just briefly speak to the basis of the motion. First of all, I think that there may have been a misunderstanding. My understanding, and unless things have changed very recently, I don't think they have, when, first of all, there are no more marital masters, but when marital masters or hearings officers that are employed by the judicial branch, when they actually conduct hearings, people are put, they have the authority to issue oaths, and people are put under oath. So they're not, those people are, they are testifying under oath. People, witnesses in those proceedings are testifying under oath. There's no need for them to have, people to have be justice of the peace. More, just as importantly, this bill, at least with the amendment, and I think even the original bill, would have proposed to make people who are appearing in mediations and neutral case evaluations, those kind of things, appear under oath. To me, that would be a terrible idea, because the whole idea of the mediations or neutral evaluations, those kind of things, is they're informal proceedings in which the idea is to try to get the parties to come together, to try to make it a sort of collegial environment where the parties will come together to an agreement. If you start saying to people that you're hoping to do that, raise your right hand, you're swearing under oath right at the beginning, it seems to me that would significantly undermine the idea of the attempt to arrive at consensus in those kind of proceedings. So for those reasons, I think that the bill is not appropriate, and I would support ITL. Anyone else wish to be heard? Representative Horgan.
A small technical issue here is that these individuals all have to be residents of, domiciled actually in the state of New Hampshire, which isn't the case now. I know back when we did have marital masters, there was at least one marital master who was in fact serving in the family court in Portsmouth, but commuting from Maine. But that.
Anyone else wish to be heard? All right. So the motion on 1550 is ITL, and I would ask the clerk to call the roll.
Vice Chairman Mannion,
Yes.
Representative Nodder,
Yes.
Representative Tripp,
Yes.
Representative Andrus,
Yes.
Representative Kutab absent, Representative Mattson,
Yes.
Representative McFarland,
Yes.
Representative Scully,
Yes.
Representative Petronel,
Yes.
Representative Birch,
Yes.
Representative Smith,
Yes.
Representative Horrigan,
Yes.
Representative Page, Representative Manos.
Yes.
Clerk votes yes. Representative Long.
Yes.
Representative Bergeron.
Yes.
And Chairman Lind.
Yes.
17-0.
Any objection to consent? Anyone have a burning desire to write the report on this?
You made the motion.
Okay,
No,
I can,
did.
all right, I can do it.
You're willing to write the report?
Oh, sure, yes.
All right, I'm gonna have you write the report. Thank you. All right, last, I would like, I'm gonna close the executive session on, House Bill 1550 and open the executive session on House Bill 1456.
I move ITL.
And I recognize Representative McFarland for a motion.
Thank you, Mr. Chairman. I move ITL.
All right, is there a second?
Second.
It's been moved by Representative McFarland, seconded by Representative Scully. Representative McFarland, you wish to speak to your motion?
I would. Thank you, Mr. Chairman. I think, first of all, this legislature does have constitutional authority to set our education policy, and removing an express acknowledgement of that authority would undermine this institution. The second point that I would make is that the proclamation that is at the heart of HB 1456, that proclamation fundamentally is a proclamation that we have reviewed, and if we accept that the legislature cannot affirm its authority, we're abdicating our duty to shape statewide policy, and we are ceding influence to other forces and to other bodies. The next thing I will say is that this proclamation declaration was part of the 2025 budget package. It was specifically part of the budget trailer bill HB2, which was a negotiated and bundled appropriations and policy set, that passed both chambers and it was signed into law. We weighed all parts of that package when we voted, and if any one piece of that package were now selectively undone, it would upset the balance of that agreement. Tax, funding, education policy were all part of the negotiation. It isn't plausible to isolate a single clause from HB2 without reopening the entire budget framework. And if members wish to unwind one piece of that deal, intellectual honesty requires that we do revisit the entire package and that comprehensive budget compromise which the House supported. The final thing that I would say, Mr. Chairman, is that the bill itself, HB 1456, that we're voting on here for ITL, it proposes to repeal RSA 141:389, which doesn't exist. The legislature's declaration of authority, which it references, was inserted as a proclamation in HB2, and it is not a permanent statute. And that means that this bill is attempting to repeal something that's not legally on the books at all as a statute, and it has no legal effect. For those reasons, I urge the rest of the committee to vote ITL.
Representative Smith.
Just a couple of comments. With all due respect, it's not a proclamation or a declaration when it's part of a bill of HB2. And HB2 is supposed to be a bill focused exclusively on language necessary in order to carry out the terms of House Bill 1, which is the actual budget with the numbers. All House Bill 2 is just supposed to be the trailer bill pulled behind the engine. One problem that we have is that we have increasingly found House Bill 2 to be used as the vehicle for passing bills that could not pass on their own, but had to pass when they were part of House Bill 2 because all of House Bill 2 had to go either up or down together. And that being acknowledged, it is also true that we have on many occasions, including in last session, gotten rid of language that we had originally put in House Bill 2 or amended that language. So whether or not this particular bill is desirable, the fact is that I think that the arguments that my distinguished colleague put before us weren't necessarily as strong and convincing as his arguments usually are. Thank you.
Follow up, Mr. Chairman.
Hang on, Representative Oregon, then Representative McFarland, then Representative Birch.
I think it's, first of all, I favor the policy behind the bill, but also I think we definitely, absolutely do have the right, to pass a bill this year that undoes something we did back in HB2. And in fact, I was just over down at the State House on the other side of the wall, which is now like the other side downtown Concord, testifying against a bill that the House passed, which was a retained bill, which and then it dealt with one particular issue, and it undid a compromise on a particular issue that was put into HB2. So that was, that obviously had the support of a majority of the House, mostly in party-line votes. So it's certainly not improper for us to consider, and I think we should pass this bill. So there's nothing wrong with undoing something in HB2, even if we, we're certainly nothing wrong with us now undoing something we did in HB2 if we think it was a mistake. And I certainly think that provision of HB2 was a mistake. So I'm going to vote in favor of it. So,
Right, Representative McFarland.
Thank you, Mr. Chairman. Just to respond to my honourable colleagues, I would say, first of all, that the actual wording of HB2 last year starts with an analysis that says this bill, item 206, proclaims that the legislature is the only branch of state government able to make final determinations over the state's educational policies. And while I respect greatly Representative Smith with her knowledge of what is appropriate and what may not be appropriate for the budget trailer bill, the fact of the matter remains that that is what the bill that we passed says, and specifically the language in that bill relating to this declaration of authority does not add, amend, remove, modify the revised statutes in any way. And hence, as much as I take Representative Horrigan's point that it is possible for us to act on a statute at a later point and reverse ourselves, there is no statute here to be acted upon, and this bill references a statute that does not exist. Thank you.
Representative Birch.
Thank you, Mr. Chair. In response to the comments of my good friend who just spoke, I'm going to say a few things. One, there was reference made that HB2 was some kind of agreement, and that if we upset one piece of it, we'd be upsetting an agreement. It's my recollection that HB2 was passed basically on a party line vote and did not reflect in the slightest bit any agreement about the merits of HB2. I would say also that the misuse of HB2, whether it's now being done by one side or perhaps in a future year being done by the other side, simply to put in bills, put in measures that would not stand up on their own, I think is destructive to the legislative process. Having said that, I also want to say that we have heard a lot this term about the authority or super authority of the legislature. And I think, I don't have the quote in front of me, it's from one of the Claremont cases, that the New Hampshire Supreme Court said that, and I'm paraphrasing, said that yes, the legislature has a lot of authority in terms of school funding and the like. But when the legislature abrogates their duty to the extent that it violates the constitutional rights of the citizens of New Hampshire, then it is appropriate, right, and important that the New Hampshire Supreme Court step up and say, whatever the legislature has done for certain kinds of bills or not done in terms of other potential legislation, when it affects the constitutional rights of citizens, it's entirely proper for the New Hampshire Supreme Court to step in and decide and the rights of the citizens of the state. So I believe that the statement, in whatever form it is, and perhaps when it gets enrolled, if it passes, they can correct the statutory reference or non-statutory reference, as the case may be, that the statement that we're voting here now that's in HB 2 is simply wrong as a matter of our Constitution, Article 137, and what the rights of the courts are in terms of the other two branches. So I will be voting against the ITO.
All right. Anyone else wish to be heard?
Yes.
Representative Ward.
Not to, maybe I'm belaboring it too much. So this particular bill overturns, I think it's RSA 141-389, which, so it is, in fact, law. It's not an RSA, but it's what they call chapter law. And so we certainly do have the right to revoke that chapter law. The instance I was talking about before, which is on an unrelated issue, they passed a chapter law, and I actually disagreed with it and brought in a floor amendment, which and it's actually some of what's in RSA HB2 actually is a bipartisan compromise, and some of it is not. But we certainly, I think we certainly do have the right, if we feel like something was put in HB2 that was a bad idea, and I think that was a bad idea, we can do so even if the thing we're getting rid of is chapter law, because that's still law. Admittedly, this particular RSA, this particular piece of chapter law is like pretty vague, and isn't really anything that's really actually enforceable about it. But it is still a law, and we are still allowed to change and revoke it if we think it's a bad idea. And I personally think it was a bad idea to put that in HB2 in the first place. So.
Anyone else wish to be heard? So I guess the only thing I would say about this is I intend to support the ITL motion, and the one point I would note is one of the things that influenced me and may have influenced others to take the position that I took on, I believe it was House Concurrent Resolution 18, the House Concurrent Resolution that said something about, what was it, 11, that said something about the Claremont, basically the legislature's authority and the court's authority. One of the things that led me to take my the position that I took, not favoring that and then eventually moving to table that, was the fact that there was a statement in the budget that I felt was less, that would be interpreted as less of an attack on the judicial branch than was in that concurrent resolution. And that was one of the things that went into my thinking on it. So I think that for all of the other reasons that Representative McFarland has pointed out, I think that's another reason. Other people may have had that same that same view, that what was in the budget, what was in HB2 was enough. We didn't need to say anything more. That's another reason why I intend to support the ITL motion on 1456. Anyone else wish to be heard? All right, I think we're ready then for a vote. The motion before us is ITL on House Bill 1456, and I'd ask the clerk to call the roll, please.
Vice Chairman Mannion.
Yes.
Representative Nodder.
Yes.
Representative Tripp.
Yes.
Representative Andrus.
Yes.
Representative Mattson.
Yes.
Representative McFarland.
Yes.
Representative Scully.
Yes.
Representative Petternow.
Yes.
Representative Birch.
No.
Representative Smith.
No.
Representative Horrigan.
No.
Representative Page. Representative Manos.
No.
Clerk votes no. Representative Long.
No.
Representative Bergeron.
No.
Chairman Lind.
Yes.
Nine yeas. 8 nays.
All right, so 9 to 8
Yep.
ITL. Oh, I'm sorry, that will definitely not be on consent. Representative McFarland, will you write the majority report?
Sure.
All right, and who will write the minority?
Yeah.
Representative
Tur, okay, all right. So that's.
Who was in the majority?
Oh, and that'll be, and that'll, I assume will be off to pass, is that correct?
Yes.
Okay. All right, I'm gonna close the executive session on House Bill 1456. And, maybe we'll take another, 2-minute break if anyone needs to use the facilities or whatever. And then we will open, in about literally 2 or 3 minutes, we'll open the hearing on House Bill 1590.
Are we gonna do 1416?
Not
Not gonna do that today.
Okay. Okay. Just clear enough.
No.
Whoops, that's not right.
Mr. Rock here.
Check.
So, just in case there's anyone in the audience that is waiting for this, I will just tell you, we are not going to have an executive session on House Bill 1416 today. Very likely, we will have that executive session on Friday of this week, but we are not going to be doing it today.
I had a question.
All right, we'll be in recess for about,
Sure, though.
So I'm going to now open the hearing on House Bill 1590. And I want to, just before I recognize Representative Scully, I just want to say, we're going to be doing hearings now on the next 1590, then 1591, and 1593, before we do any further executive sessions. And so I would just say, I know that we haven't taken a lunch break, and I apologize for that. But since we're doing hearings, we don't need a quorum. If anybody is really hungry and wants to step out to, grab a quick bite, you'll have at least a little time to do that because we're going to be doing hearings right now. And with that, I'm going to recognize, I'm going to recognize Representative Scully. He is the sponsor, so he will not be subject to this limit, but for the rest of the witnesses, it'll be a 2-minute limit on testimony. Representative Scully.
Thank you, Chairman Lynn and honorable members of the committee. For the record, my name is Kevin Scully. I'm a state representative representing Hillsborough District 8, Ward 6 in Nashua. And I'm here to introduce Bill 1590 FM to our committee. I believe there is a serious civil rights violation and constitutional conflict in existing law, and HB 1590 has been submitted to repair the conflict in these laws. I believe there is no conflict between us regarding what is a person. There has been a profound area of disagreement in our society regarding when is a person, meaning the age of a child's fetal development when personhood is recognized and their constitutional protections begin. In New Hampshire, the age of personhood was established in 2017 when the fetal homicide law was passed, and RSA 630:1A was amended to include a developed human being at the end of 20 weeks of fetal development as being another, separate from the mother. RSA 631A prescribes that a person causing the death of another after the end of 20 weeks has committed a homicide. Since you cannot commit a homicide without killing a person, the age of personhood has been established and remains unchallenged. And our Constitution makes no exceptions. All persons are entitled to the same constitutional protections of life and liberty that you and I enjoy. The problem this bill seeks to cure was created when the Fetal Life Protection Act, which was RSA 329:44, was passed in 2021. That law allows the killing of an unborn developing person for any reason up to the age of 24 weeks. But the age of personhood had already been established at 20 weeks and has not changed. So the Fetal Life Protection Act effectively created a special class of lesser person who the state allows to be killed during the period from 21 weeks to 24 weeks without due process for any reason. I believe this violates the following New Hampshire constitutional articles. Article 2, which is natural rights. All men have certain natural, essential, and inherent rights, among which are enjoying and defending life. Article 16, jury trial in capital cases. Nor shall the legislature make any law that shall subject any person to a capital punishment without trial by jury. And then finally, Article 18, penalties ought to be proportional to the offenses. All penalties ought to be proportional to the nature of the offense. No wise legislature will affix the same punishment to the crimes of theft, forgery, and the like, which they do to those of murder and treason. I submit to you, given that the state has declared you to be a person at the end of 20 weeks, that you cannot be subject to capital punishment without due process. And if you are a person being aborted at 23 weeks, it is certainly capital punishment for you. So clearly, the age of personhood must be harmonized in order to remove these constitutional violations. This bill sets the age of RSA 329:44 to 20 weeks, the already established date of personhood at the time the Fetal Life Protection Act was passed. It is the age established by law, and it is the age that should have been recognized and employed when the Fetal Life Protection Act was passed. If this bill passes, a woman will still retain the right to terminate her pregnancy up to 20 weeks, which is 5 months, for any reason. In addition, the pregnancy can still be terminated after that point if the continued pregnancy poses a severe risk to a woman's health or life. Let us not forget, more women are born than men. So let's not leave these developing women, declared to be persons by the state, out of the discussion regarding women's rights, the right to life being the most basic. In closing, my fellow legislators, we have all sworn to uphold and defend the Constitution. This bill corrects a serious conflict to our Constitution, and I ask that you work with me to correct this wrong. Thank you. I am available for questions.
Questions for this witness, Representative Turin.
Thank you, Mr. Chair. Thanks for taking the question. So if there's this conflict between these two dates, I'm curious for two reasons. One is we know that our current governor has stated pretty clearly that she does not wish to change the statutes regarding abortion. And also from a technical standpoint, the typical date for an ultrasound for fetal anatomy checks is done at 20 weeks, my understanding. So this puts the medical decision-making process right at the same limit as the time that you're proposing. So I guess my question is, why change this date instead of the earlier date passed for the homicide bill?
Perhaps you can, are you asking why 20 weeks instead of 24?
Well, what I'm really asking is why modify this section of law rather than modify the other section of law to be 24 weeks?
When you say, all right, again, I'm sorry, I guess I'm not quite understanding the question. I will tell you that, when looking at this, there was a decision that I made to try to make both laws 20 weeks. And I think there are multiple reasons for doing this. So, before I get into those, I do want to state one other question. I don't consider this an abortion bill. This is a civil rights bill. We've declared people at 20 weeks to be persons, and they are entitled to constitutional protections. So I feel like we cannot leave this discrepancy on the books because, again, we're violating basic principles of the Constitution in terms of civil rights protections. So that needs to be fixed. Regarding why we would use 20 weeks rather than 24, I would say that the first reason is that the age and personhood had already been established. We had a law in the books that remains unchallenged that says you're a person at 20 weeks. So the reason why they used 24 weeks was the fact that Roe v. Wade was still the operating ruling in the nation, and that had used what I consider to be the arbitrary 24-week cutoff as a place where the state could assert its compelling interest to protect viable life. Roe v. Wade is no longer in effect. So now we can go back and look at this issue again, and I think it's perfectly reasonable to set it at 20 weeks, given that that age of personhood is already on the books. May I continue? Because there's two other reasons why I think we ought to make it 20 weeks. Is it appropriate for me to do that?
Well, sure. Go ahead.
Well, thank you. I think this is a hugely important issue, and I think it needs to be addressed. The second is, if you agree with the legal reasoning of Roe v. Wade, they, again, in that decision had decided that the state had a compelling interest when there was a potential of viability. At the time Roe v. Wade was passed in 1973, the common age of viability was considered to be 28 weeks. And what Roe v. Wade says that children as young as 24 weeks had survived, and so therefore they erred on the side of conservancy and set their cutoff at 24 weeks. Modern medicine and the miracles of our modern medicine have pushed that time back. There are children who have survived as early as 21 weeks. So if you accept the logic of the Roe v. Wade decision, 24 weeks is no longer protecting potentially viable children. It needs to be rolled back. And there's third and final reason I would say that we should keep the date at 20 weeks for both. It's the precedent that would be set if we as a legislature start thinking that we can exclude people from the concept of personhood for political convenience. There are two separate ways of looking at human beings. One is to say that they are unique creations, different from all other animals, and have an intrinsic value into and of themselves that needs to be respected. The other way of looking at this is to say that your value as a person is only determined by how much value you have to society or to another. I would remind you that the Nazis, when they decided to go on their genocidal campaign, passed the Nuremberg laws, they made sure everything was legal in terms of what they did. They started excluding people who they thought were inconvenient or people they hated from the definition of personhood in order to be able to do what they did legally. So when they were defeated at the end of the Second World War, and we found out the horrors of what they had done to human beings, the Germans turned around and said it was all legal. So we had to create this whole concept of crimes against humanity because what they did was legal, because the legislature decided that they could start reducing the concept of what a person was to suit their purposes. So I would say to you, we have set that date. It's 20 weeks, and I would urge you to think long and hard before you decide that you can start reducing the definition of personhood for personal convenience.
Yes, follow-up question.
Sorry, my one quick follow-up, thanks for your responses. Do you agree with the proposition that at either of these levels, it is a legislative act that is setting this and that there's no underlying inherent cutoff point that we must adhere to when making these determinations?
You're absolutely right. It is the power of the legislation to do so. I would just ask that we really look to the lessons of history and decide before we start going down that road. It leads to terrible places.
All right, other questions, Representative Birch?
Thank you, Mr. Chair. Thank you, Representative, for taking my question. You premise your, as it were, constitutional or legal argument on the basis that Statute A, which was a protective anti-homicide, anti-assault, whatever, purpose, that a definition of an age there is relevant to a different statute talking about abortion and the like, and saying what's good for one is good for the other, more or less. So my question is, because I'm not sure why that would be so, my question is, if we take another example, for kids in this state, they can register to vote at 17 and vote at 18, but they can't drink until they're 21. So is that 21 age unconstitutional because a different statute creates rights at age 18? And then I'm thinking about the right to drive, which in New Hampshire, you can get a learner's permit, I believe, at 15 and a half, and you can get a driver's license at 16. So isn't it true that because the rights of let's say my teenager to vote, drink, and drive, is defined differently according to age in different statutes. And why would you say because statute A says 20 weeks and statute B says 24 is a constitutional problem?
The definition in right to life is so fundamental and underpinning to all of our laws in our Constitution. It's something that's an entirely different level of importance. The other issues of when you can drive and when you can vote could be viewed as inconveniences. Taking somebody's life is not an inconvenience.
Other questions? Seeing none, thank you very much. Next.
Thank you for hearing me.
Next, I'm going to call on Representative Crystal Lloyd, please. Yes, and I'm imposing a two-minute time limit now for the rest of the witnesses.
Thank you, Mr. Chairman. I'll get through this as fast as I can. I'm angry. I'm angry that many who have probably had zero issues of getting pregnant or having children are sitting here trying to make laws which will directly affect my ability to have a child. Let me explain. There are many reasons why this legislation is a bad idea, but this is my personal story, and it affects me personally, a colleague that all of you work with. My husband and I have been trying to have a child for years now. We have been unsuccessful though so far. At the end of January, I started our first round of IVF, and after a week and a half of injections, my doctor brought me in for egg recovery on February 9th. Of the 15 follicles she was looking at, they were only able to recover 8 eggs. Of those 8 eggs, only 5 were able to be fertilized. Of those 5 fertilized eggs, only 2 were able to mature into usable embryos. Those 2 embryos are graded on how viable they are. From the grading I currently see on my health portal, both of them have only a 25% chance of live birth. This tells me with each one I have a 75% chance of miscarriage at some point, or a 75% chance of non-viable pregnancy. I have not yet gotten the genetic testing back on the embryos, and if we go through with either of these 2 things, anything could change at any point during the pregnancy. I am 42 years old. The very second I become pregnant, this will be a high-risk pregnancy for both me and my future child. If I'm able to get pregnant and have a child, this will be the most loved and wanted baby. I have both my husband's family and mine, as well as a wonderful community surrounding me through my church and in Nashua, just waiting to welcome them to the world, if they make it, and if I make it. I am already concerned about our existing law, which limits us to 24 weeks.
So you're at the 2-minute. Sorry. Questions for this witness? Seeing none, thank you very much.
If you have written testimony, you can turn it in.
I will be turning it in. Thank you.
Next, I'm going to call on Representative Susan Van Castile.
Well, good afternoon. Thank you, Mr. Chairman, my fellow state reps and granted staters. Representative Sue Van Castile from Salem, New Hampshire, District 25. I am first and foremost a granted stater, then an American. And I'm well aware of the Roe versus Wade, how it became, how it left, and it was left up to individual states. Most of us know how it came into law, not just legislation, but it got in through with the big package. Just like the New Hampshire state inspection. It went through legislation, but it went in with a big budget. So I am here begging everybody, every citizen of the state of New Hampshire, to allow us to enforce the 14th Amendment. When we have to make a decision, whether it's 2 weeks, 3 weeks, 20 weeks, 20, 30, it's a very personal decision and it belongs to our family in our living room. I just want to think, I know the proper way in the New Hampshire State Constitution is to do a CACR, which we tried. I joined late. I'm sorry for that. But I want to be like the great Donald Trump, our president. He thinks outside the box. He gets things done. Does he push it a little bit to the edge? Maybe. But it's making a difference and it's making America great again. The proper way is to allow the Granite Staters to have a vote, put it on the ballot, and allow them to have a say, not just rely on us. When I took my oath, I promised that I would uphold it and I would vote on my constituents, my conscience, and then my party, which I have. And I've been judged. Not many people care for me. I know a lot of people love to hate me. But I'm begging this committee. I'm begging the governor. I'm asking President Donald Trump step up and allow the Granite Staters, the great Granite Staters,
Time is up.
thank you, to make our state great again. Any questions?
Questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Brooke.
Thank you for the
Caldwell.
opportunity.
Brooke Caldwell, please.
Hello, my name is Brooke Cadwell. I'm a certified nurse midwife and a psychiatric mental health nurse practitioner. Received my medical training at Yale University and Johns Hopkins University. And I am here to express my strong opposition to House Bill 1590. In my role, I not only provide midwifery care and obstetric and gynecological care, but I train medical residents, medical students, nursing students, and I also do a significant amount of research. My recent research has been focused on healthcare deserts, which I think is especially pertinent to this bill today. As of 2024, 1 in every 25 obstetric units has closed its doors. Currently, over 35% of U.S. counties are considered maternal care deserts, meaning there are no hospitals or birth centers offering obstetric care and no OBGYN providers. One of the main driving forces behind these closures and lack of care is restrictive practice laws specifically related to abortion care. Abortion is a subject that evokes passionate feelings from many people, and thus legislation related to abortion is continually a hot button issue. I want for a moment for everyone to ignore abortion and look at the bill for what it really means for our communities. It is crucial to remember that when we lose OBGYN providers, we don't simply lose obstetric care, we lose gynecological care too. Studies show that women receive upwards of 74% of their preventative care from OBGYN providers. This means cancer screenings, chronic health condition management, such as hypertension and diabetes, mental health care, family planning. The list is endless. Every time we lose an OBGYN provider, countless women in the community lose their access to health care. Once we pass these laws, we threaten all aspects of medical autonomy. It's not just restricted to abortion care. And I think it's very easy to omit these conversations when we discuss bills such as House Bill 1590. Medical decisions are sometimes small, but most times they are nuanced, highly sensitive, and very subjective, and should be made between an individual, their family, and their trusted care providers. Care providers who have spent their lives learning and training to provide the best care for patients.
If you have written testimony, you're certainly happy that you can pass it in, but.
I will type it up and
Are there
submit it.
questions
Thank you.
for this witness? Seeing none, thank you. Next, I'm going to call on Nancy Brennan, please.
Thank you. This testimony actually comes from Amy Agostino, who is a neonatal nurse and mother who lives in Londonderry. Fetal personhood is a vague and deceptive term. HB 1590 is an abortion ban, and there are many reasons why even a 20-week abortion ban is bad for pregnant women. Even the term abortion is misconstrued outside of a medical setting. It refers to the ending of a pregnancy and sometimes to procedures used to end pregnancy. Did you know that in official medical terms, what we call a miscarriage is documented as a spontaneous abortion? Lay people seem to think, due to rampant misinformation, that abortion usually means that some woman gets pregnant, perhaps irresponsibly and repeatedly, and decides to just get an abortion as a casual form of birth control, and that somehow doctors and healthcare facilities blithely roll along. Healthcare facilities are not fast food drive-through. You cannot just go up to the window, order an abortion procedure, and be told that will be this many dollars, drive on up and have a nice day. From Pew Research, 1% of abortions in the U.S. occur after 20 weeks, 1%. The reasons usually involve a severe and unforeseen medical complication. These are not elective procedures. Any pregnancy termination happening after 20 weeks is happening because something has gone terribly wrong. Pregnancy complications after 20 weeks can be life-threatening. Healthcare professionals go into the medical field to help people, spending years in school, passing licensing exams, and taking ethical oaths. Please let us do our jobs without the state government trying to preemptively second-guess how to deal with true
Thank you.
obstetric emergencies.
Time is
Thank
up.
you.
You have questions for this witness? Seeing none, thank you very much. Next, Dr. Ogyung, please.
My name is Dr. Ogyung. I will forego my introduction, which you already heard this morning. I want to thank all of you for hearing me speak. I'm here opposed to House Bill 1590. The bill specifically bans termination of a pregnancy after 20 weeks gestation, criminalizing physicians if they violate this ban. You must understand there's a significant difference between 20 and 24 weeks gestation. During these weeks, complications occur where the 20-week ban challenges our care. I want to demonstrate with just one example, a complication called an incompetent cervix or cervical insufficiency occurring 1 in 100 pregnancies, uncommon but not rare. Women classically present at 18 to 22 weeks gestation with a well-dilated cervix in the absence of labor. Their water breaks. The standard care is to induce labor at that point, terminating the pregnancy to avoid severe maternal infection and allow that woman to hold her newborn during its final breaths. Should we have to worry about criminal charges in these circumstances? A colleague suggested to me, oh, just call a legislator. They're the people who will decide whether you can terminate that pregnancy. But you know nothing about my patient. You know nothing about obstetrics. You know nothing about this complication. Lawmakers should have no voice in the care of our pregnant patients. I ask you to oppose House Bill 1590. Thank you.
All right. Questions for this witness? Yes, Representative Notter.
Thank you, Mr. Chairman. Thank you for taking the question. In your opinion, what species is a 20-week preborn baby?
Say that again. What
species?
What species?
As in human?
It's a human fetus.
Thank you.
Other questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Michelle Johnson, please.
Good afternoon. My name is Michelle Johnson. I'm from Cheshire County, New Hampshire. The abortion law in the books now is Title 30, Occupations and Professions, Section 329.44. It is not a criminal law and does not need to be conformed to the criminal law because there is no interaction or overlap between the two. In New Hampshire, a civil verdict can be reached with only 10 jurors. Criminal conviction requires a unanimous verdict. Civil plaintiffs need only prove their cases by a preponderance of the evidence, but which is just over 50% certainty. criminal prosecutors must prove their cases beyond a reasonable doubt. RSA 329 does not need to be conformed with the standards of criminal law any more than the standards of proof in civil and criminal trials need to be conformed. Variation between civil and criminal law is not talking out of both sides of our mouths, as was said in an interview with the Keene Sentinel a few days ago. It is following literally centuries of precedent. The reasoning, also in that interview, that the vast majority of abortions occur early in a pregnancy in any case, is a bit callous, given that the abortions that occur post 20 weeks are generally because of devastating fetal anomaly. Amniocentesis is not generally administered until 16 to 20 weeks. It can be done as early as 11 weeks, but that endangers the baby. The blood tests necessary to detect genetic anomalies such as trisomy 13 and 18, both of which almost guarantee the baby's death within a year, 90% of them within a week after birth, are not done until 12 weeks. It takes 2 weeks to get the results. When I had to have that done, it took another 4 weeks to get an appointment with a geneticist to see what we were really facing. So now we're up to 18 weeks. When I got the results, the doctor told me I must do an amnio because I must abort because the baby would die. I wanted to have more information before I made that choice. But at 18 weeks, I wouldn't have even been able to get an appointment with the 2 centers
Sorry,
in New
your
Hampshire that offer that.
Your time is up. Questions for this witness? Seeing none, thank you very much. Next, Emily Zajano, please. And on deck will be Fidelma McKenna, I believe. Yes. Hi.
Good afternoon, Chair Lynn and House Judiciary Committee members. My name is Emily Zajano. I'm a resident of Exeter and a pediatric emergency medicine physician, and I'm asking you to oppose HB 1590. 20 weeks is an arbitrary date. My experience highlights the fact that pregnancies can have complications that do not fit into any person's or legislation's timeline. I had 2 abortions at 17 and 19 weeks. It was my first pregnancy and very much wanted by my husband and me. We were shocked and thrilled when our first scan at 12 weeks showed 2 babies. However, the ultrasound also showed I had a uterine anomaly, a potentially life-threatening condition. The twins were in 2 different areas of my uterus. More studies suggested I was safe and we would have our baby girls. At 16 weeks and 4 days pregnant, I woke up in pain that became so severe it hurt to breathe. Ultimately, we learned the uterine wall on the left side had ruptured, and the fetus on the right had severe congenital heart disease. These findings changed everything. I was hemorrhaging internally, and the fetuses were not at viability. In surgery, they saved the unicornate uterus, and the fetus on the right was still there. But it was clear that allowing this pregnancy to continue would put me at huge risk. 2 weeks later, we went back for the second abortion. If HB 1590 passes, a patient in a similar situation could have a drastically different outcome. For me, my doctors may have needed to wait until I had ruptured the other side of my uterus, hemorrhaging again, before providing the care I needed, in order to protect themselves legally. I would have lost my uterus and possibly my life. I would not have my 2 living children that followed my devastating first pregnancy. I may not be here today. This bill creates confusion that will replace medical judgment with legal fear, harm New Hampshire citizens, and weaken our medical system. Please vote ITL on HB 1590. Thank you for your time and your service.
Thank you. Questions for this witness? Question, Representative Nader? Oh, I'm sorry, Representative Petterno. Sorry.
Thank you. Thank you, Mr. Chairman, and thank you for taking my question. Would you believe, this is not really a would you believe question, but I've been in a very similar situation. And is there anything in the current law that would prevent treatment in the case of a medical emergency? Because in Roman numeral 1, under the Fetal Life Protection Act, it says, except in the case of a medical emergency. And it sounds like your situation was a medical emergency.
I resent that I need to spell out every path of this worst time of my life to try to create a safe place for people to be pregnant. the complications that can arise with pregnancies, as you are going to hear from several doctors today, the complications are so varied that there is not a law that can thread the needle to protect every person in every pregnancy. We need to leave the decisions to the doctors and the patients in the room who make the best choices for themselves.
Other questions for this witness? Seeing none, thank you. Next, Fidelma McKenna, and on deck will be Jean Brown.
Sorry, I might sound teary because that person's testimony was so beautiful and I appreciate it so much. My name is Fidelma McKenna, and I'm asking you to oppose this bill. I'm a midwife at Southern New Hampshire, or I'm a midwife in Nashua. The term midwife comes from the Old English mitwife, with women, to accompany, witness, and support a community member, friend, patient through their reproductive life, from first period through menopause and aging. In my work as a midwife, I accompany and care for patients through many difficult and fraught decisions during their life, including how, if, and when to have a baby. In this work, I'm keenly aware that pregnancy carries many risks that can be life-threatening, and it's a constantly evolving process of risk assessment. Continuing to limit access to abortion from what the state has already imposed in 2021 on its population from 24 weeks to 20 endangers my patients further. 20 weeks is too early to have the information necessary that some patients will need to make truly heartbreaking decisions regarding tragic and unexpected anomalies. It also introduces uncertainty into the provider's ability to address emergencies. We have trained for years to become experts in this care. We've stayed up all night with your constituents, rubbing backs, holding legs, encouraging them with kind words. We are very well prepared in what we do. Please embody the spirit of New Hampshire's Live Free or Die and keep the government out of these very personal and private decisions that should be between the patients, your constituents, and their highly trained providers. Additionally, I train OBGYN residents from Boston, and we know that increasing restrictions to abortion care will turn prospective providers away from working in the state, worsening access to care for your rural constituents. Thank you so much for your time, and I will not be taking questions.
Thank you. Next is Jean Brown, and on deck is Amy Teravacchia. And I think I've finally pronounced that correctly. Yes.
Good afternoon. My name is Jean Brown. I live in Hanover, New Hampshire. I'm urging you to oppose HB 1590. In 1991, I was 39 years old and was pregnant with my first child. I discovered at the 20-week mark with the amniocentesis that due to a trisomy 18, the fetus would not live outside my womb. It was actually no decision for me. I did not want to carry a baby, then going to die. I wanted an abortion, and I was able to get one. My body would have been okay if I continued the pregnancy and delivered a stillborn baby, but I would not have been emotionally willing to go through that experience. At the base of it is the right of a woman to control her body. It is inappropriate, with all due respect, for a state governing body to set itself up as a medical expert in the field of reproductive health. That is imposing a religious tenet that has no business in government. I do not want to live in a theocracy. And I think it is reprehensible that this law threatens doctors with jail time and fines for doing their jobs and working to provide the most appropriate evidence-based care to their patients. A few months after my abortion, I was able to conceive a healthy baby boy who's now turning 34. Every woman should have that same care. That's why I'm urging you to oppose HB 1590. Pregnancy is just too complicated and unpredictable for one-size-fits-all laws. Being able to have an abortion is about making private decisions best for a woman and her family. It is their business, no one else's. Doctors deserve our trust and respect. Women deserve support and options. I appreciate your time and your service. Thank you for considering my testimony.
Thank you. Questions for this witness? Seeing none, thank you very much. Amy Teravacchia, and on deck will be Michael Michaud.
Good afternoon. My name is Amy Teravacchia. I'm a resident of New Hampshire and with 603 Equality. I oppose HB 1590. I'd like to share a personal story today. First, I currently have 2 healthy children, which I'm very grateful for. My daughter's my firstborn, and she has every ounce of preteen right now. But had a very healthy pregnancy with her. We were both healthy throughout, which I'm very grateful for. And after she was born, I knew I wanted a second child. That second child did not come easily to me. I discovered at 12 weeks that my second pregnancy was not viable. It was the week of Christmas, and although my doctor thought it was a good idea to schedule a D&C, which is a procedure that is abortion healthcare, the lack of providers in the state, coupled with the timing of my miscarriage, meant that I would have to wait. So I miscarried at home instead. Thankfully for me, it was safe to do so, and I experienced no health risks. But miscarrying while caring for a toddler at home was very difficult, both emotionally and physically. Trying to create the joy of Christmas morning was very difficult to do while enduring that. And despite all this, my spouse and I chose to keep trying. Eventually, pregnancy made it past the 12-week mark, which we were thrilled about. And then at an 18-week scan, something didn't look right again. The view of the fetus's heart was blocked, but what was visible was a brain tumor. My provider explained that this could be a sign of trisomy 18. This is a condition that 2 other testifiers have mentioned today, a rare genetic condition. And the fetus that I was carrying, if they had trisomy 18, it wouldn't mean a life of pain. It would mean most likely a stillborn child. I thought back to the emotional and mental toll of my first miscarriage and what that was like to experience while caring for myself and for my daughter. And I take parenting very seriously. I take being a
Thank you,
present.
ma'am. Your time is up. Questions for this witness? Seeing none, thank you. Michelle Michaud, or Michael Michaud, I'm sorry, and Cynthia Rasmussen will be on deck.
Thank you to the committee. My name is Mike Michaud. I'm a resident of Dover. I'm in opposition to this bill. More than 30 years ago, my wife and I were excited when we found out she was pregnant. Results of a routine ultrasound performed between 28 and 30 weeks shocked us. The baby had numerous challenges in many of his systems. He had multiple heart conditions, issues with his spinal column, multiple missing organs, multiple issues with his brain. The important point here is that we went into 2 months of discovery about his conditions, which all contributed to an extremely complex situation. I can't stress enough that his issues individually were potentially treatable, but the complexity of his overall condition was dire. Given the technology at the time, we could not determine in utero if his condition was fatal. There was no abnormality incompatible with life. The complexity of his conditions was the problem. Connor was born 2 months later. Once he was delivered, we found out there was no way to save him. We transitioned to comfort care. One of us was holding him the entire time, and he was in extreme pain the entire time. He was on adult doses of morphine by the time he died. If we had been able to determine his prognosis while Connor was still in utero, we would have likely opted for an abortion to save him from the pain he experienced in those 3 days. Couples going through similar conditions now won't have the time needed to consider what's best for their family. The doctors would be at risk of committing a felony because they couldn't point to a specific condition incompatible with life. The complexity of these situations cannot be legislated. We spent 2 months with specialists from a lot of disciplines trying to determine a path forward for Connor. No one except for the people who have lived it have any idea how traumatic and complex these situations can be. Everyone else should be thankful they cannot understand how hard this is. This is not something I would wish on anyone else. I have written testimony.
Thank you very much, sir. Questions for this witness? Seeing none, thank you. Cynthia Rasmussen, and on deck will be Dr. Melly Martinez.
Chairman and committee members. My name is Dr. Cynthia Rasmussen, and I'm a New Hampshire resident and an OBGYN physician retired after 32 years of practice. I'm here to express my opposition to House Bill 1590 because I feel that it's bad medicine and bad for the people of New Hampshire. This bill is bad medicine because it's not consistent with medical reality. The 20-week cutoff was the result of an arbitrary political compromise in order to pass the fetal homicide bill in 2017. It's not based on any medical or scientific standards. The ultrasound exam that detects severe fetal conditions usually happens between 18 and 22 weeks, Families then need time to confirm the diagnosis, obtain high-risk referrals, and make difficult and deeply personal decisions before second trimester terminations can even be considered. This places many families well beyond the 20-week cutoff of this bill. Criminalizing emergency obstetrical management places healthcare providers in the untenable position of either obeying the law and committing medical malpractice or performing appropriate medical interventions and committing a felony. To quote one OBGYN in a recent journal article, quote, "You have somebody hemorrhaging with an intrauterine pregnancy and a heartbeat, but there's only so many times that you can transfuse somebody and they're begging for their life before you say, this is unconscionable." This is bad for the people of New Hampshire because abortion bans create healthcare deserts. They discourage women healthcare providers from thinking about coming to New Hampshire, from continuing to practice in New Hampshire, or if they're of reproductive age, of living in New Hampshire, especially when every surrounding New England state has enacted more reasonable restrictions and stronger protections for its providers and its citizens. In recent polling, 89% of Granite Staters feel that we have the right to make decisions about our own bodies without undue government interference. A 20-week ban replaces a private medical decision with a government mandate and violates the concepts of personal agency and equality under the law. 20-week bans disproportionately affect those in rural areas, people of color, minors, and low-income individuals.
Your time is up. Thank you very much. Questions for this witness? Seeing none, thank you.
Could I respond to another question that was asked earlier?
No, you had your time. Thank
Okay.
you. Dr. Melanie Martinez, and then on deck is Dr. Julia Mead.
Hello, everybody. My name is Dr. Melissa Martinez Adorno, and I'm currently the chair of the New Hampshire section of the American College of OBGYNs, as well as a board member of the New Hampshire Medical Society. In order to ensure that the rest of the folks here are going to testify, I'm not going to be taking any questions today, but I've submitted my testimony online already, where my contact information is available, and you can all follow up with me if needed. I've been an OBGYN in this state for over 2 decades. Caring for the women of New Hampshire has been my life's greatest privilege. This bill is framed as a technical harmonization. In reality, it will be a profoundly cruel consequence for the patients of New Hampshire, particularly those experiencing catastrophic pregnancy complications. A fetal anatomical ultrasound is performed between 19 and 20 weeks of gestation, and this is when the majority of our patients find out that there's a really significant problem with their pregnancy. By lowering the statutory threshold from 24 to 20 weeks, we will be including felony penalties into clinical decision-making. When criminal liability enters the exam room, hesitation follows, delay follows. And in obstetrics, the delay can mean sepsis, organ failure, potential future infertility, death. Our patients will be transferred out of this state to be able to receive appropriate evidence-based medical care. They'll not be able to be cared for by their own physicians, the providers they've established a therapeutic relationship with, because they will have to be sent across state lines because the New Hampshire state legislature has decided to enter the exam room to be able to decide for me what the appropriate medical decision to make with my patient in shared decision-making is. They're entering into what is appropriate evidence-based medical care inappropriately. New Hampshire already struggles with limited obstetric coverage in some of our rural areas. Policies that threaten felony prosecution will drive providers away and will keep our med students and residents who are training in this state to take care of our patients from staying here. They will choose different locations to work. That does not protect life. It reduces access to emergency care for women who want to continue their pregnancies and for those who are facing tragic medical realities. Thank you.
Time's up. All right, next I'm going to call on Dr. Julia Mead, and next will be Dr. Amy Lee, I believe. Yeah.
My name is Dr. Julia Mead. I'm an OBGYN physician, and I practice in New Hampshire. I appear before you today on behalf of the American College of Obstetricians and Gynecologists in opposition to HB 1590. It bans a legal, safe healthcare option a full month earlier than the current law and would criminalize myself and my colleagues for doing the job we love and that we're highly trained to do. I had a patient recently who found out at 20 weeks that her baby had no kidneys. This is not a baby who could ever survive despite all of our advances in modern medicine. Legislatures should not be deciding how this patient will manage her pregnancy moving forward. Patients should be able to decide with their doctors and their families what medical care is right for them, not politicians. I had another patient who was otherwise healthy, had a normal anatomy ultrasound at 20 weeks. A few days later, her water broke. She didn't do anything wrong. Her pregnancy had been perfectly normal up to this point. There's no chance her baby could survive given how early her water broke. And if she was forced to watch and wait, her life could be at risk. Patients in her situation face heartbreaking choices, but these choices should not be made by legislators. For women who are forced by state laws to watch and wait rather than pursue an abortion, almost half of these women will suffer from severe infection or severe bleeding, and 1 in 3 women will end up in the intensive care unit if their water breaks extremely prematurely. Women should not have to wait until they are deathly ill to get care in our state, but that is exactly what 1590 does. It's not safe for patients, it's not grounded in medicine and science, and it will increase maternal morbidity and mortality. Women will die because of this law. Requiring physicians to treat patients based on legislation rather than science and medicine and the individual patient in front of them gives legislatures and the court significant power over decisions made in the exam room, rather than relying on highly trained physicians
Thank you, ma'am.
and patient autonomy.
Your time's up. Thank you. Questions for this witness?
I will not take questions.
None. Next, Dr. Amy Lee and Callie, and on deck is Dr. Callie Sullivan.
Hi, I'm Dr. Amy Lee. I am a resident physician practicing in New Hampshire and speaking on behalf of myself and on behalf of ACOG in opposition of HB 1590. I'm a physician in training. I came here 4 years ago with the intent to train to become an OBGYN. As part of this training, abortion is a specific requirement. You're required to do at least 20 abortions and to become an OBGYN practicing. When you look for where you're going to train, you look for places that have that full spectrum of gestational age. Because if I do those 20 abortions in only 6-week pregnancies, I will not be able to care for everybody. And I see this bill and I see that it has medical exemptions. Both you and I would break a promise to that patient, because even though there's a medical exemption, neither of us can provide that care. I wasn't trained in that care, and you had promised that they could get that care, but you didn't provide the grounds for the physicians in the state to get the training to care for them at that point. I'm personally leaving New Hampshire. Usually about 50% of residents stay in New Hampshire. The past 2 years, no residents are staying. Part of my choice, and truly something that I feel bad about because New Hampshire has given me so much in training, but part of that choice is I am going to a state where I am fully protected and I have no felony charges coming against me if I was to provide the standard of care for patients. Thank you.
Thank you. Questions for this witness? Seeing none, Dr. Callie Sullivan, and next on deck is Kayla Montgomery. Dr. Sullivan is not here, okay? All right, then Kayla Montgomery, and next on deck will be Claire Leone.
Good afternoon, members of the Judiciary Committee. My name is Kayla Montgomery. I'm the Vice President of Public Affairs for Planned Parenthood Northern New England and our State Action Fund. I just want to say up front that, and perhaps I'm dating myself here, but I was in the room for both the personhood bill and for New Hampshire's abortion ban. So, if you have any questions about any of the legislative history, I'd be more than happy to answer any of those. Back in 2018, this body put critical legislative safeguards into the original personhood bill, but this bill removes it. The reason they put those legislative safeguards in was so that the personhood bill wouldn't become an abortion ban, but that's exactly what this bill would do. So I know we've heard a lot about a 20-week ban and what it means. I just want to talk a little bit about what in general all of this means in practice for the people of New Hampshire. So first, as I think this committee knows, this does establish a 20-week abortion ban, which of course is a full month earlier than current law and often before critical tests can be done.
It also expands the criminalization of our highly trained, competent New Hampshire doctors. It applies first-degree murder charges to any pregnant person who violates the ban. And something that is incredibly alarming is that in addition, this is all alarming, it blows the door wide open for any woman who is experiencing pregnancy complications to be investigated and charged with first-degree murder. So for example, if a woman has a stillbirth at home at 21 weeks, she can now be investigated under this law. So, what might have previously been understood as a tragic stillborn in New Hampshire could, if this bill passed, instead inspire providers and law enforcement to ask whether a pregnant person, quote, did something wrong or tried to end her pregnancy without any evidence of that or not. And I know that that was never the legislative intent of the original personhood law that passed less than a decade ago. I also, this sounds like hyperbole, but it's not. This month in Kentucky, a woman was charged with a reckless homicide when she had a miscarriage at home. So I will end my testimony there, and I'm happy to take any questions.
Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you.
Next is Claire Tellioni, and on deck will be Dr. Maris Tollett.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Claire Tellioni. I'm here on behalf of Reproductive Equity Now to testify in strong opposition to HB 1590. This bill would grant legal rights to fetuses at 20 weeks gestation under the criminal code, which is, as you've heard, a full month earlier than New Hampshire law currently restricts abortion care. In states that have taken similar steps to expand fetal personhood under homicide laws, we've seen a very troubling rise in criminalization of pregnancy outcomes and of pregnancy loss, even when the law includes a carve-out for abortion care. That's what's at stake if this bill advances for Granite Staters. When laws confer personhood status into the criminal code, pregnancy outcomes have the potential to become crime scenes. Healthcare providers become potential witnesses against their own patients, and pregnant women, especially those who are low income or those who may be facing health challenges, become vulnerable to surveillance and to prosecution. This bill very dangerously merges a criminal statute with healthcare law. Criminal penalties for the commitment of a crime and the statutory authorization of healthcare services should not be and are not interchangeable. The bill risks turning deeply personal medical events into matters for law enforcement. And that's not a hypothetical, as you heard my colleague just before me mention. It's something we're watching unfold across the country right now. New Hampshire should not follow this path. Granite Staters deserve compassionate health care, not criminalization. So I urge the committee to find HB 1590 inexpedient to legislate. Thank you.
Thank you. Questions for this witness? Seeing none, thank you. Dr. Maris Tolland, and on deck will be Ann Walls. Push the button. Should be red. There you go.
Should be red.
Thank you.
Confusing. My name is Dr. Maris Toland. I'm an obstetrician gynecologist in the southern part of the state. I live in Manchester, practice in the southern region. I'd like to expound a little bit on the last couple of testimonies about sort of the personhood component of this bill. I think I want everybody to sort of realize how much significance that this can place on the people of New Hampshire and things that we're realistically seeing in other parts of the country. I think in the last number of years, I've seen a lot of increasing misinformation coming from patients in legislative sessions between AI and misinformation on the internet. A lot of people think that they know a lot more about obstetrics as a field than is actually accurate. So I think it's important to note the number of healthcare providers that show up to these committee meetings, physicians who are actually practicing in obstetrics, and what their opinions are about bills like this and how they actually are applied in realistic situations. Across the country, there are real ramifications and consequences to bills like this against individual people who can be prosecuted for miscarriages, which happen in 1 in 4, 1 in 5 pregnancies, far more than people realize. as well as huge ethical and moral cans of worms with IVF and personhood of embryos, all sorts of ethical and moral issues that come up with this. And then I would like to just also mention that the physician shortage is a real issue. And for anybody who thinks that this is not something that's applicable to the state of New Hampshire, it is. There's a paper that came out in 2026, just this year in January, that projects that in 2035, New Hampshire, as a state, will only have 80% of the workforce needed in obstetrics and gynecology in order to take care of its population. So
Time is up. Thank you.
this is real.
Questions for this witness? Yep, Representative Birch.
Thank you. I'm not sure it's best directed to you as opposed to the other medical folks here, but could you explain a little bit how this bill may have adverse effects for those seeking IVF treatment?
Sure. So I don't know if anybody's been following what's been going on, like in Georgia in the courts. But, you know, when you label a fetus as a person with its own rights, then that can then therefore be transferred into the thought of embryo. When people are undergoing IVF or in vitro fertilization, they often have embryos that are frozen and stored for future use. You know, this opens up a legal challenge of saying, are each of those embryos their own person in their own right? If those embryos are not, we heard from somebody today that embryos can be categorized on sort of quality. You know, if they are not a quality that is acceptable or successful, you know, anticipated to be successful to be implanted in the uterus, then, you know, what happens if you discard those embryos? This legally can open up a theoretical option to then criminalize people who then discard embryos that were not expected to actually be able to turn into a person, but legally we've given personhood legal, you know, qualification to these cells. You know, day 5, a clump of 10 cells or so, and so you know it brings up a lot of challenges for the IVF field. And if you hear from infertility doctor, now I'm not an infertility doctor, but infertility doctors across the country have spoken out widely against bills with this sort of language because it really impedes access to infertility care, which frankly is already very challenging across the state and across the country for families to get access to.
Other questions for this witness? Yes, Representative Notter.
Thank you, Mr. Chairman, and thank you for taking the question. At what point do you consider the unborn a human?
I don't think that's a reasonable question to ask because, you know, that's not something that we really consider in this situation. The medical reality is that this entire field is very, you know, medically gray. You know, I think lay people who don't go through medical training think that there's a clear answer of like, well, at this point, it turns out, you know, it becomes clear, it's black and white. And the truth is in medicine, nothing is black and white. Everything is gray. Every situation is unique. And we do our very best as physicians to balance the risks and benefits of any situation. And frankly, the number of possible complications in pregnancy is so wide and so varied that that question doesn't really factor into what we're talking about today. What we're talking about today is legislative interference into the practice of medicine, which has real implications to not only patients' health, but also physicians' ability to practice, you know, in a way that is sustainable for them. You know, there are practices in southern New Hampshire. I can name many practices. They're all hiring. They're all looking for doctors. There are people I know who are actively leaving the state. You know, this shortage and this interference into the practice of medicine is a real issue in this country. And bills like this that are kind of looking at the wrong thing, but looking at ways to legislate the practice of a field that people don't have the technical expertise to understand is a huge problem.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, Ann Walls, and on deck is Rachel Potter, please. Ann Walls? Apparently Ms. Walls is not here. Then Rachel Potter, please. And on deck is Hazel Kane.
Good afternoon, Mr. Chair, honorable members of the Judiciary Committee. For the record, my name is Rachel Potter, Policy Associate at the ACLU of New Hampshire, and I'm here to oppose HB 1590. The title of this legislation talks about harmonizing the law, and I want to start by saying that this bill does not simply harmonize the law. It merges two fundamentally different areas of New Hampshire law, the criminal homicide statute and the medical abortion regulatory statute, and in doing so, it transforms the legal framework governing abortion care. And right now, as you've heard, those areas operate independently, and this bill just collapses that separation. It expands the concept of fetal personhood within the criminal code and ties abortion to that framework, effectively converting healthcare into an exception to homicide. And that is not a technical change, it is a structural change. Under this bill, abortion would no longer be presumptively lawful, regulated healthcare here. Instead, its legality would depend on strict compliance with a narrow statutory exception, as you've heard from the doctors here. Supporters of the bill may point to the exception for legal abortions in the bill, but that protection is conditional, and I want to make that clear. HB 1590 ties the legality to precise procedural compliance while redefining abortion in relation to homicide law. Legal protections would only exist if every requirement is satisfied. Otherwise, the conduct would fall within a criminal framework. And when homicide sits adjacent to medical decision-making, a lot of serious legal questions arise. What qualifies as a medical emergency? Who decides that? How would a miscarriage be distinguished from an induced abortion? What about self-managed abortion? Could providers or even family members face investigation for aiding and abetting? Embedding abortion within the homicide statute invites criminal investigation into pregnancy outcomes and forces doctors to practice with first-degree murder law in the background.
Thank you, ma'am. Your time is up. Questions for this witness? Representative Horgan.
Yes, I want to ask you about you since from your since your former career you were involved in this with the legislative history of it. So it makes the Fetal Life Protection Act stricter. And if I recall correctly, wasn't that act passed in 2021, the year when things were kind of disrupted by the pandemic as part of the budget trailer bill, so it's not really fully debated as a bill by itself. Is that your recollection too?
Yeah, I think that would be correct recollection. Sure.
Thank you.
Other questions for this witness? Seeing none, thank you very much. Next, Hazel Kane, and on deck is Representative Joseph Clark.
All right. Good afternoon. Thank the Honorable Judiciary Committee for having me here. My name is Hazel Kane, and I am testifying in opposition to House Bill 1590. I think we really need to sit with the gravity of what this bill is, in that it is removing the exemptions for pregnant women who cause the death of their fetus from a prosecution for first-degree murder that carries a mandatory sentence of life without parole. A man who recklessly beats a friend or family member to death gets treated better under the state. It's called manslaughter, a maximum sentence of 30 years. What we're saying by this law, by allowing pregnant women who obtain an abortion in violation of the Fetal Life Protection Act, is that they are essentially equivalent to a capital murderer, a cop killer, and really a first-degree murder is effectively the strongest sentence you can get since the death penalty was abolished in the state. We're saying that people, I have friends, I have had partners, I have had family members who would all be considered effectively capital murderers under the statute. And we know that the people who get abortions are not violent men who beat their wives to death in a rage. These are teenage girls. These are young, poor women who cannot afford to have a child. These are people who maybe have had too many children. They cannot afford to have another one. And what we're saying is that they can be locked away for the rest of their lives and never see the light of day because we've decided that a 20-week fetus is on the same level as a born, living human being who has contributed so much to society, that we've decided that other sentient beings somehow can deserve less protections than this fetus. I don't think there's much more to say on this. I can't believe we're even having a debate on this legislation. And I think because I want to make your time short, I will not be taking any questions. Thank you.
Thank you very much. Next, Representative Joseph Barton, and then on deck will be Jason Hennessy.
Thank you, Mr. Chair. Representative Barton, Grafton District 1. I want to remind the committee that this bill does seek to harmonize the 344 with 631A, which is a result of Griffin's Law, which was passed in 2018. We do have a responsibility as legislatures to protect those natural rights that are in our state constitution, one being the right to life for the born and the unborn, defined at 20 weeks now per 631A. There's some misunderstandings. I think this does not, on first read, extend to IVF. It pertains to the termination of actual pregnancies. Specific termination. It doesn't apply to stillborn births or miscarriages either. They don't fall within the definitions defined in this legislation. And the exceptions are not narrow, and they're also already codified. This bill doesn't seek to change any exceptions within the existing law. So I think that all it does is harmonize with 631A, bringing it from 24 weeks down to 20 weeks, and I fully support this legislation. I'm happy to take questions.
Questions? Yes, Representative McFarland.
Thank you, Mr. Chairman. If the intent of the bill is about harmonization, then would you support if the bill was amended to stay 24 weeks?
Are you suggesting changing 630 to 24 weeks from 20 weeks?
I'm suggesting if you're looking for harmonization at 20, would you also support harmonization at 24?
I would not, because the existing statute, what's already codified, says 20 weeks.
Other questions for this witness? Seeing none, thank you very much, sir. Next, Jason Hennessy, please.
Hello again. My name is Jason Hennessy. I'm the president of New Hampshire Right to Life, and we support this bill with amendment. The first thing I want to talk about is human rights. So after about 14 to 15 weeks, a child in the womb, as verified by the latest science, can feel pain. So after 20 weeks or so, they can feel their limbs being pulled. And if you're interested in the citations, please go to our website. We have several of them. I would ask those who believe in bodily autonomy from the earlier hearing, would they also support abortion pill reversal? Because in those cases, many blue states are getting in the ways of of women and their doctors who are trying to reverse their abortions. Generally, I do agree with bodily autonomy, but we have to keep in mind that in a pregnancy, there's two people there. You have the mother and the child. And what we argue for is that we just want to take both of their humanities into account under our laws. Most cultures and mainline believers in religion agree with this throughout time. You can look at the Greeks, for instance, with the Hippocratic Oath that explicitly forbids abortion. And it's the legislature's job to protect life under our Constitution. In terms of the medical things I've heard, I just want to point out two things. One is that there are 2 peer-reviewed studies on the number of OBs that do abortions. The lower estimate is 85% do not do abortions. The higher one is in the 90s somewhere. So in terms of getting OBs, it would actually, like most actually don't agree with abortion. In terms of IVF, I would remind the person who made that comment that the fetal homicide bill currently exempts IVF explicitly. And that is most of my testimony. I'd happy to take questions.
Questions for this witness? Seeing none, thank you.
Thank you.
I don't have any other pink cards. Is there anyone else who wishes to be heard on House Bill 1590? Yes, you need to fill out a card, please.
Thank you, Mr. Chair. I'll fill out a pink card. Just for the record, Representative Kelly Potenza, Stratford District 19. I thought a lot about this bill when I signed on as a co-sponsor, and because I knew what this hearing was going to be about. I knew that it was going to go on, and there was going to be so much discussion about this, and I just find it sad because nobody wants to have the conversations about abortion at this point, but I think with everything that's going on in our country, and I'm sorry I have to say it in regards with Epstein files and all this kind of stuff with forced pregnancies and forced abortions and all of this kind of stuff, when our law is crystal clear that we say that a personhood exists at 20 weeks, and then we pass something through a budget that says 24, and that is an inherent conflict. It's not saying that a mother is going to be a murderer or any of those types of things. And I don't understand why we wouldn't want that to be harmonious. It doesn't. We can't talk out of both sides of our mouth where we say, yes, 20 weeks, it's a person, and then okay, but no, it's, if you're going to decide to do that on your own for whatever reason that you want, it's 24. It just doesn't make sense. It's inherently conflicts, and we have these all over the place in New Hampshire statute. I talked to folks on all sides of the aisle, and I don't even think that we should be passing laws anymore. I think we should just work on repealing and amending, because we have layers and layers and layers of all these conflicts that are in there, and that's just why I think this was a great bill. And of course we're going to have, there's just a lot of, it gets heated and all of these types of things, but I don't want mothers to be called murderers or anything like that. I really do believe that if we say that it's a life, that they have personhood at that point in 20
Thank you very
weeks,
much,
then we have to do that. So I hope the committee makes the right decision in this. Thank you.
Questions for this witness? Seeing none, thank you very much. Again, is there anyone else who wishes to be heard on House Bill 1590? Seeing none, I'm going to close the hearing on House Bill 1590, and I'm going to open the hearing on House Bill 1591. And Chair recognizes Representative Potenza. I'm doing all right. Like this. No, Eric, how are you?
I would not want to be Eric today. I would not want to be.
All right.
Any other day.
Oh, that's for sure.
Oh, yeah.
Right. Right. Sure. 1591, Representative Potenza?
We still need a card from her too.
Thank you.
Good.
Look, Representative, excuse me, Ms. Werner? Yeah.
Go ahead, sit down. He'll be right back.
All right. I'm sorry, Representative Potenza.
All right, we're in.
Thank you, Mr. Chair. Once again, just for the record, Representative Kelly Potenza, Stratford District 19. So I'm here in testimony to introduce, of course, in full support of HB 1591. I just wanted to let you know that I put in a small amendment, which I'll explain afterwards. It's really important for this bill. So thank you, Mr. Chairman, of course, members of the committee. I know you've had a long day thus far. So HB 1591 as amended addresses a narrow but a real serious gap in New Hampshire law regarding how courts handle lost, abandoned, or unclaimed property. So under RSA 471C, virtually every public and private entity in the state that holds abandoned property is required to follow clearly defined procedures and ultimately remit that property to the state treasurer. The courts right now are the sole exception to that problem. By statute, abandoned funds held by the courts are to be handled in accordance with procedures established by the Supreme Court. Yet when those procedures were requested this fall for a constituent, no one could identify what they are, not the general counsel of the judicial branch and not the court clerks themselves. That is a problem. So this bill doesn't expand judicial authority. It does not interfere with case outcomes. It does not appropriate funds. It simply requires the courts holding abandoned or unclaimed property follow the same statutory framework already established in RSA 471C, just like every other holder of abandoned property in New Hampshire. So this issue came to light because of a constituents whose funds, more than $40,000, have been held by a Rockingham County court since February of 2022. Under RSA 471C15, those funds became legally abandoned over a year ago, yet they remain in court custody with no identifiable procedure, no timeline, and no clear path for resolution. This is not a theoretical concern. That's like real money belonging to a real person being held indefinitely without statutory guardrails. So HB 1591 ensures that courts are subject to clear defined procedures when holding abandoned property. Constituents are not left in limbo due to internal uncertainty or missing guidance, and the judicial branch is brought into alignment with the Uniform Abandoned Property Framework already enacted by this legislature. So the bill is really about clarity, accountability, and fairness. No branch of government should be exempt from basic statutory standards when holding private property, especially when those standards already exist and are working very well, actually, elsewhere. For those reasons, I respectfully ask the committee to recommend HB 1591 as amended, as ought to pass, and I'm happy to answer any questions. I submitted the amendment, which is basically, if you want to, I don't have the bill in front of me, but it's under Part 2 where it says, a court which is holding lost, abandoned, or unclaimed property subject to this chapter, it now goes to shall dispose of it in accordance with procedures established in this chapter. That was a mistake in drafting, which we have since fixed. And that's the amendment that is in drafting now. Simple couple word changes that you guys will have, you'll have by the end of the day today or tomorrow.
Questions for this witness? Yes, Representative Birch.
Thank you, Representative. I was trying to figure out what this bill was about. Is there any mention of unclaimed or abandoned property in the bill? Those words?
I don't know. I'd have to grab it. That's the whole point of it. That's what RSA 471C is.
If I could follow up?
Yes.
The bill specifically refers to property held in escrow, registry, or trust.
Correct.
And are you aware that funds are currently being held for any length of time by the Supreme Court and its administrative system in escrow, registry, or trust?
Yes, that's what I just testified to, that this bill was written because of a constituent.
So, Representative Turner.
Maybe this is what you're going to ask. Could you say a little bit more about, do you have any insight into why this property, because it's not something that we've heard happening to others. Is there a reason why you know that this property happens to be in this situation, and do you know if it's happening to others?
I don't know if it's happening to others. It doesn't matter. It's happening to one, and that's the reason why I'm here. I literally spoke with the court, the clerks of the court directly about this. Everything that I just testified to, where I said, yet when those procedures were requested this fall, no one could identify what they are because there is no procedures, not the general counsel of the judicial branch and not the court clerks themselves. So I've literally injected myself in the situation. The court order is crystal clear. I read the court order, which came out at the end of January of 2022 for $43,000 and da-da-da-da. And they still have this person's money, and there's no reason why.
Follow up, Representative Turner.
Yeah, thanks. I guess I still just want to circle back to, do we have any insight into why this money is not being released? And is it a policy procedure question, or is there something else going on that's causing the court to be holding these funds?
No, there's no policy, there's no procedure question, there's nothing. There's, as I said, they don't follow the same, they need to follow the same rules under like the abandoned property piece, which of course this money is still being held in escrow, which is after 3 years, it has to go and go to the Treasury. The court needs to follow that. So, and they're not. And they didn't have any, they couldn't give me any reason why. I asked them specifically. There was a clerk that was filling in for the full-time clerk. When I had called, I spoke to both of them eventually, and she had no idea why. She goes, I don't understand why we still have this money in escrow. So this is the reason why this bill is in place. It was a heated case. It was a family court case, a divorce case, and but it doesn't matter. I have no idea if this. It would be really, really nice to know if this is happening in any way. But the fact of the matter is that there shouldn't be one entity at all that's not following this procedure. That there shouldn't be any exception for the judicial versus every other aspect that has to return, like I said, on abandoned property, escrowed, all of that kind of stuff needs to go back to the state treasury, and we should keep it consistent in our law.
All right, other questions? Representative Birch.
Thank you. Maybe I can try to approach it differently. From what you've said, it's my understanding that there were claimants to this property in some kind of order in 2022. Is that correct?
In 2022, the court ordered the money to be given to the individual. Yes.
So if I could follow up, so we're not talking here about abandoned property. We're talking about property that some claimant says that they should have that hasn't, for whatever reason, been released to them.
I'm not really sure. I'm using this, my testimony was in general. Yes, this money was put into escrow in 2022, early in 2022. After the 3-year mark, the court should have given that over to the state treasury. That's what this bill does. That's what this bill does. It keeps it in alignment. So that the court shouldn't be able to hold on to it. And it is considered at that point, because it hasn't been picked up, it's considered abandoned at that point. Yes, it is.
Other questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Lauren Warner. Lauren Warren, please. Warner, sorry.
Good afternoon, honorable members of the committee. My name is Lauren Warner, and I serve as Deputy General Counsel for the Judicial Branch. Just speaking briefly on HB 1591, I haven't reviewed the amendment, but just speaking as to the original bill, which requires the Judicial Branch to return funds held in escrow or trust or the like after a court order has been issued. For example, also I would say in lines 13 through 14, it requires that the branch complete the disbursements within 30 days of receipt of a copy of the final order awarding said funds. The branch's practice is to promptly return all funds. In cases which funds may be held are court orders which include conditions that must be met, ordered by the judge before the funds can be awarded. I am aware of one case in which funds are being held where there are conditions that the party who will be awarded said funds must complete and provide documentation to the court that those conditions have been completed to award said funds then. Or another case could be the judicial branch requires a W-9 to be completed to then disperse the funds. Those would be the two lawful cases in which the branch's practice would be to withhold funds, but otherwise funds which are...
Is the case that you referenced in which the conditions have not been met, is that the case that Representative Potenza was talking about?
I believe so. I didn't hear the name of that individual, but that is the 2022 matter that then has been, I know an initial letter has been sent to the branch to look into it, but based on the history of this, the conditions hadn't been completed yet or documentation thereof wasn't provided. That's why the funds have been continued to be held.
If I'm understanding correctly, this property was not abandoned in any sense. Is that right? It belonged to somebody.
Correct. And Representative Burgess noting, yes, for the abandoned property, the 471C, that relates to property which there is no claimant that can be identified or come to. So those traditionally, prior to my position with the judicial branch, I worked as the deputy state treasurer and oversaw the abandoned property program. Those are funds in which there is no claimant identified. So it typically.
So am I understanding correctly that the problem in the case that was identified is the money was supposed to be turned over to somebody, provided that somebody satisfied certain conditions. And what you're telling us is the conditions have not been satisfied.
Based on what so I haven't worked on this specific matter, but when speaking with Judge Keating, our office that is looking into this, the conditions have not been met, or at least documentation of any conditions that were proposed in the order hasn't been received, and that's why the funds had been withheld.
So can I just add, my recollection, correct me if I'm wrong in this, my recollection from the time that I was a judge was the court system was always anxious. We didn't want to be hanging on to money. We don't get any interest on it. We don't get any benefit from it. We wanted to get rid of money that was being held if it belonged to somebody. And there was a push to get rid of the money so we could get it off the books. Have things changed? Is this a problem that you've got lots of money hanging around that you're not, that people are clamoring for and you're not giving it back to them?
This is not a problem that I'm aware of. This is the only instance in which I'm aware of where there is someone seeking to further return of funds and is working with the branch.
Other questions for this witness? Yes, Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. The sponsor of this bill made it very plain that there doesn't seem to be any process for returning funds. But you've explained that the funds are not being held, unless there's a reason. Do you believe that this bill has any merit and that we should go forward with it?
Well, I would say that the current process for the branch is to properly return funds so it's mirroring what is currently done. That, and I think based on the fiscal note we also provided, we don't believe that there are funds that are in existence that are unlawfully being withheld by the judicial branch. So is it necessary? I don't believe so from my perspective, but the practice is for the judicial branch to return funds upon a court order which orders funds. If any conditions need to be satisfied, documentation needs to be provided to the court to then lawfully return those funds. And then we have the process of completing a W-9 to return funds, but this isn't a practice to withhold funds by any means.
Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. Excuse my ignorance, because it really is ignorance about the situation. But I'm not clear why the judicial branch would even have funds that are held in escrow. In my practice in the family court, I've never had that experience. So if there are funds to be escrowed, for example, if you have parties that are divorcing and the house is to be sold,
yeah,
and there's a dispute between the parties as to how the funds should be divided, they're put in an escrow account, but it's not an account with it's not an escrow with the judicial branch. The parties agree on an escrow agent, and that's where the funds go.
So in this specific instance, which I believe is the one that's up, it was over a dispute regarding property and selling of funds, and so those were held by the judicial branch in that case because there was numerous. And I apologize, I wasn't around during the time of that case to know, but based on my reading of the information I've received, there was disagreement as to like the values of the properties being sold, something being remortgaged. It was those funds were held by the judicial branch in escrow. Well, the court ordered like what each party was going to be awarded, and then to receive the additional funds, there was some conditions that needed to be met prior to the final disbursement.
Yes, Representative Smith.
Thank you very much. The sponsor had a number of occasions said that the money should be released and sent to the Treasury. But is that really what do you think that is really what the sponsor's constituent wants? Wouldn't the sponsor's constituent want the money to go to the constituent? The money, as I understand it, that goes to the Treasury stays in the Treasury. It goes in the Treasury because it's been abandoned for the appropriate period of time, and then from then on, it's state money. Am I wrong?
So I can't speak as to what the constituent might want, but you are correct in the process that then property which is deemed abandoned under the 471C, we don't have an actual individual available to provide said funds. So in these cases where money is escrowed by the judicial branch, we are aware of who that individual is, who those funds would go to, as opposed to abandoned property where it's typically you aren't aware of any heirs, or it's a bank account that's been abandoned and you don't know who the claimant for the funds is, and that's why it's sent to the state. And in said cases, say for example, if in this case that money were to go to the state through the abandoned property system, I would think there would be an issue of who would determine if there was a court order and have those conditions been satisfied to then award that money. Would that be the state treasurer then that would be in charge of having to do that, ensure the order's been complied with? Like that would potentially create additional problems as opposed to the money held in escrow with the court to review to determine the conditions have been met.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Is there anyone else who wishes to be heard on House Bill 1591? Yeah. No, I'm sorry. No. All right. All right. Seeing none, I'm going to close the hearing on House Bill 1591. Now I'm going to open the hearing. Oh, okay. I'm going to.
Never got a card for her.
Oh, okay. Sorry. We don't. All right, next I'm going to open the hearing on House Bill 1593 and recognize Representative Megan Murray, please.
Good afternoon. I'd like to introduce myself. My name is Representative Megan Murray. I represent Hillsborough County District 37, the towns of Milford and Amherst. And I'm here to introduce House Bill 1593 as one of the co-sponsors, as the prime sponsor is not here today. As a co-sponsor of House Bill 1593, I know that folks often think of Section 504 of the Rehabilitation Act of 1973 and federal disability protections in the context of schools, higher education, housing, transportation, employment, and public service sectors, but it also applies to the context of healthcare. It is important to acknowledge that any program receiving federal or state assistance be held in the same clarity under the law as it relates to disability discrimination and relative protections for individuals living with a disability. We understand these, especially in education, in order to provide reasonable accommodations for preferred methods and choices for access to accommodation upon request. That said, as we all know, New Hampshire is the second most aging state in the nation, and whether folks age in place in their homes or age in transition, I'd like to share a scenario that happened to a loved one in another state who, through no fault of their own, was asked to give up utilizing their motorized wheelchair that they had used and operated effectively for decades, and were requested to strictly use a manual wheelchair with an aid to operate it as a condition for entering a skilled nursing facility in their home state. The request was made to address a liability concern, but such a request is dehumanizing and takes a person's autonomy away, and at the very same time that they are needing professional skilled care, given their health circumstances, places a person in an uncomfortable situation. The reality is that a loved one transitioning into a new phase and level of care met with uncertainty and new changes enough, while simultaneously navigating changes in family living dynamics. Asking them to give up an adaptive mobility device vital for their independent personhood is not only morally wrong, but is a violation of several aspects of federal law, including 504 disability protections in healthcare. Codifying 504 disability protections in New Hampshire state law is a good move for the state and will present a clear roadmap for families and individuals about their rights, as well as to set a clear set of expectations to entities who fall under those guidelines. For individuals like my loved one, having these stipulated in statute would make access more clear and would allow New Hampshire to continue to lead in this way. There are speakers who will come after me who will speak to other aspects of the bill, but this piece of legislation will provide clarity, transparency, and a state framework to navigate policy, and will reduce mistakes and disenfranchisements like this from happening here in New Hampshire. I urge the body to vote for this legislation as ought to pass. Thank you.
Questions for this witness? Representative Birch.
Just to say it briefly, in the state that sometimes doesn't always choose to enforce federal law at the state level, such as some of our gun laws and the like, is the purpose of this bill basically to take the federal ADA and make sure it's part of state law?
Thank you for the question, Representative. Also, actually, ADA and 504, this is addressing 504 most specifically, but yes, the intention is to bring some of that federal statute into state statute for ease of interpretation and also clarity for those constituents who need those protections.
Other questions? So I'm sorry, did anybody else have a question? So I guess I want to make sure I understand. Can you just tell me if this became law, this bill became law, what would this bill cover that is not already covered by federal law?
That's a great question. This is an effort to continue to address some of the things that are happening federally sometimes that are removing pieces of clarity and protection at the federal level. And if there were more broad and sweeping changes with regard to 504 or ADA protections, this would ensure that our state continues to lead in a way that has those 504 protections codified in state law as well.
So can you just, if I'm understanding you, and correct me if I'm misinterpreting, but it sounds like what you're saying is that there is no difference between what federal law now covers and this law would cover, but you're concerned that federal law somehow might at some point be cut back. Is that correct?
Thank you for the question. There are some small differences between the federal law, and to that end, there are folks behind me who will speak with more clarity and specificity to those nuanced changes. But yes, the desire is to see the 504 replicated in state statute.
Thank you. Other yes, Representative McFarland.
Thank you, Mr. Chairman. I very much appreciate your and Representative Birch's questions, because I think my first point of view when I read this was I was perplexed as to why, and I think you've laid that out now as to why you believe that the federal anti-discrimination laws might be subject to change. But when I think about this, as you said, from a New Hampshire standpoint, where in our Constitution, shouldn't there be a distinction between what government is forbidden to do and what we enforce and require that private individuals may not do?
I'm not sure I understand your question with regard to disability protections.
Well, let me rephrase then. If we agree that the state must not discriminate, on what basis do we say that the private individual should not?
With all due respect, this is about ensuring that individuals who have differing needs for protection, and there are a myriad of circumstances in where protections are necessary for individuals for very good reason. So if I'm understanding,
I'm just hoping you can quote
question,
an actual constitutional basis for saying that we can enforce this against individuals within the state.
So any entity that receives state or federal funding currently has an obligation to meet anti-discrimination laws. So I'm not understanding your question with regard to.
Never mind.
Other questions? Seeing none, thank you very much. Next, I'm going to call on Gretchen Fishman, and for the other witnesses now that are coming, I'm going to impose a two-minute time limit, please.
Hi, thanks for having me. I'm Gretchen Fishman. I'm here today in support of this bill. I am a special education and disability justice advocate, but I'm here today also as a parent. My children have experienced the deep pain of educational neglect and the lasting trauma that comes from being discriminated against by the very systems meant to support them. When a child is denied the basic tools they need to learn because of their disability, it is not just a paperwork error, it's a violation that stays with them for a lifetime. Right now, New Hampshire families like mine are in a vulnerable position if our children face discrimination in a state-funded or program or community college. Our own state's Commission for Human Rights often can't help because our laws have a college gap and lack the broad coverage of federal law. We're forced to wait for federal agencies to step in, a process that can take years while our children continue to suffer. This is especially dangerous right now. 9 states are currently suing to dismantle the federal disability protections we've relied on for 50 years. If those lawsuits succeed, the federal safety net my children depend on could vanish. We can't leave the rights of Granite Staters to the whims of a court case in Texas. This bill changes the game for New Hampshire families by, this isn't inclusive, writing federal non-discrimination standards directly into New Hampshire state law. It allows parents to go to a New Hampshire court for an immediate solution rather than having to wait for a distant federal agency. It allows for the recovery of attorneys' fees so families don't have to go bankrupt just to fight for their child's civil rights. And it ensures that every part of our state-funded system, from hospitals to higher education, are held to the same standard of fairness. New Hampshire has the opportunity to lead the nation. We can codify non-discrimination protections.
Thank you, ma'am. I'm sorry, your time is up. Questions for this witness? Seeing none, thank you.
Thank
Next,
you.
I'm going to call on Aaron Fishman, and on deck will be Brendan Matt.
Members of the committee, my name is Evan Eastler Fishman, and on behalf of the neurodivergent people, I speak to you today to support this bill. Support is an understatement. I was overjoyed when I heard of this bill. I lost my early childhood to autism discrimination and denial of accommodations. Reflecting on my past fills my heart with sorrow, anger, and grief. I mourn the reality that was supposed to be, but never was, and the reality is the one being proposed in this bill. And no matter the outcome of this hearing, I will never stop speaking for my people, because no human being, no one like you or me, deserves to get robbed just because they think differently. Our early years are gifts we only have the privilege of living once. So can the people of New Hampshire in good consciousness rob someone of that? Are you willing to inflict years of emotional trauma to children who have done no wrong to you because they think differently? Albert Einstein and Sir Isaac Newton are people who thought differently on the spectrum like me and revolutionized society. To say you want to deny this bill is to say you want to discriminate against those scientists, against innocent people who have done no wrong to you. In my eyes, discrimination against neurodivergent people and people with disability is equally as evil as racism and sexism. That is my testimony.
Thank you very much. Questions for this witness? Seeing none, thank you. Next is Brendan Madden, and on deck will be Patricia Vincent Pratt.
Thank you, Mr. Chairman, members of the committee. My name is Brendan Madden, and I live in Dover, New Hampshire. I am currently in the New Hampshire Leadership Series, a leadership program run by the Institute of Disability at UNH. A classmate of mine, Gretchen Fishman, proposed the idea for this bill. I graduated with an associate's degree in liberal arts from Great Bay Community College. When I was there, I was able to take many marketing and business classes, which have been extremely helpful to me in my current role as chairman of a nonprofit. Because after high school, I began attending college part-time, but I was diagnosed with a brain tumor. Thankfully, it was successfully removed. After hard work at an acute rehab facility, I made the decision to return to college because earning a degree was important to me. I was dismayed to discover that during the Leadership Series program that there is no discrimination clause for post-secondary institutions under state law. Instead, Great Bay has its own clause in place. I encourage you to vote for an ought to pass so that students with disabilities in New Hampshire have the opportunities that I had and access to legal protections and higher education. Thank you for your time.
Thank you, sir. Questions for this witness? Seeing none, thank you. Next, Patricia Vincent Pratt, and on deck will be Louis Esposito.
Thank you to everyone on the committee for listening to me today. I'm here in support of the bill. Back in 1977, 4 years after the 504 originally passed, dozens of disability advocates staged a sit-in almost for a month, putting their lives on the line to force the federal government to enact Section 504. Many of those participants had lifelong health problems because of that, but they changed the world for millions of disabled Americans. Growing up before 504, meant that my husband had to attend, my husband Jim, right here, had to attend school miles away from his friends and family. He missed out on his brother's hockey games, neighborhood get-togethers, and the friendships that most kids forge in their own communities because his school was not required to accommodate his disability. The first time he voted, he had to vote in someone's car while people stood around and watched him because his polling place was not accessible to him. He had to fight for access to higher learning, and once he graduated, he couldn't find a job that his dean's list status should have entitled him to. For decades, 504 has ensured young people with disabilities don't have to face the same discrimination as Jim, although we've seen from other testimony that they still are because these laws are not being properly enforced. And they face the mental anguish that comes with this. As the federal government and other states attempt to roll back these protections, let's show them that New Hampshire is different. Let's pass this bill because all Granite Seers deserve to live free.
Thank you very much, ma'am. Questions for this witness? Seeing none, thank you. Next, I'm going to call on Louis Esposito, and on deck will be Michelle McCannagy.
I hope I have enough copies. If I don't, I'll send you some emails. But good afternoon, Chairman Lynn and members of the committee. My name is Louis Esposito. I'm the Executive Director of ABLE New Hampshire. We are a grassroots disability justice organization. Section 504 of the Rehabilitation Act is a federal civil rights law that says if you receive public money, you cannot discriminate against someone because of their disability. That's why kids get 504 plans in school. That's why hospitals have to provide accessible equipment. And that's why publicly funded housing programs cannot turn somebody away. 1593 takes protections of rights them into New Hampshire law. Not new rights, the same rights, but enforceable here by us in our New Hampshire courts. And the reason this matters is because right now the federal system that is supposed to enforce these protections is collapsing right in front of us. The Office for Civil Rights at the Department of Education, which is an agency a family calls when a child's disabilities are violated at school, has lost nearly half its staff. Complaints are going unanswered. A February 2026 Government Accountability Office report found that almost 90% of the 9,000 complaints were dismissed. The Administration for Community Living, the federal agency that funds Meals on Wheels, Centers for Independent Living, and programs that keep disabled people and adults in their homes instead of nursing facilities, was dismantled last spring. 78 fair housing anti-discrimination grants were terminated overnight. These are the grants that funded the organizations that handle the majority of housing discrimination complaints. And 9 states right now are suing to overturn the integration mandate, which is a Supreme Court principle from Olmstead, that disabled people have the right to live in their communities and not be warehoused in institutions. So the federal picture is that. And I think we as New Hampshire citizens need to ask ourselves some tough questions. And, should we be depending on a system that looks just like I explained? And I don't think they should. And I think HB 1593 says that you don't need to. And what this bill does is says that in New Hampshire, if you are a student who needs accommodations and your school won't provide them, if you are a deaf student at a community college and courses are not captioned, if you're a veteran with a traumatic brain injury who needs written instructions and a flexible schedule at a state-funded job training program, and you are told no, you have somewhere to go. You have a courtroom in this state that can handle this. And I want to be clear, the intention is not to necessarily,
Thank you, sir. Your time is up. Questions for this witness? Yes. Representative Birch.
Thank you. Perhaps you might address a question that came earlier about state constitutional basis for anti-discrimination laws. And I'm wondering if you would comment on Article 2 of the New Hampshire Bill of Rights as amended in 1974 that establishes that equality of rights under the law shall not be denied or abridged by this state on account of race, creed, color, sex, or national origin?
1974 still predates IDEA. It predates ADA, and it predates some of the things we're talking about now. I don't necessarily feel comfortable. I'm not a lawyer. These things are really complicated for me, and I do apologize if I could look into that and get back to you about it. But I do know that there are a lot of citizens right now in New Hampshire that are very nervous about what's going on at the federal level and their protections. And the aim of this bill is to essentially codify that into state law and make it more of a granted state solution to this problem. And we have a long history of doing so.
Representative Page.
But did you submit written testimony?
I will. I have the testimony going around, but I could submit that as well and email it to you.
Yeah, because I see you've got a packet kind of explaining.
Yeah, I wrote that pretty late last night. But
But your testimony here, your testimony here seems to be a little deviating from what that
Yeah.
packet said, right?
yeah,
Yes.
yeah. I mean, it was like 15 pages with resources and citations, and trying to condense it to 2 minutes is kind of complicated.
Okay, thanks.
Representative Horgan.
I guess my first question is, so this document, which is obviously, I mean, it would have probably been worthwhile to sit here and have you give a verbal presentation of all 15 pages, but that's not how we're doing it. But that is available. Is that available on the online testimony portal or somewhere else?
Yep, I can
Cool.
submit it
Thanks.
on there. Yeah.
And also, I haven't had a chance to read the whole thing, but flipping through it, I did see something jumped out of page 9, which, if there's concern about the cost, you point out the fiscal note for F-1593 is clear. The bill imposes no cost on the state unless the state itself is found to be discriminating. So could you clarify, maybe like tell us a little bit more about that?
I mean, I think, all state and, federal money should be, covering this. So if New Hampshire is, taking into account disabled granite staters, it shouldn't have a fiscal impact.
Okay, great. Thanks.
Representative Smith.
Thank you. I'm thinking a lot about our efforts to have our discriminatory. Let me reword this. I'm sorry. I'm thinking a lot about what we have done in this state in the past when we tried to take the lessons in federal legislation and have our state laws comply with the federal legislation because the federal legislation really did set a high goal for us, ADA compliant, whatever, a whole series of things. I'm wondering if the worm has turned, so to speak, and that now our concern is that perhaps there may be a weakening of commitment to people with disabilities on the federal side. And is this bill then an attempt to hold firm with New Hampshire's good intentions in that area?
Absolutely. New Hampshire has a very long history of being out front with issues regarding the disability community, ranging from, a lot of the families involved in the 70s with Special Olympics being a very primary driver up until the closure of a lot of the state-run institutions. New Hampshire's always been at the forefront and has gone above and beyond. And one of the things I keep hearing, and one of the things our members and people within our community are very nervous about, is what's going on at the federal level. And we have these laws in place, and a lot of people have fought excessively hard over the past 40, 50 years. There's a big movement in the 70s to make sure that this was enacted, and we don't want to lose progress. We want to make sure that we are we have the rights and protections that we are promised from our federal constitution, and what better way to put it into state law?
Other questions? Yeah, of course. Yeah.
Follow up. Historically, I don't like to be partisan. I don't think in a partisan way. But is it not true that historically in the state of New Hampshire, it was the Republican leadership in the governorship and in the House and the Senate who worked so hard to make sure that, particularly in schools, that people with disabilities were protected?
Absolutely. Disability has a long history of being bipartisan. 1990, it was President George H.W. Bush that passed it. 70s IDEA, I believe that was under, I think that was Ford, right around that time, for 76 was Carter. So it is a long history of being a bipartisan issue, and disability doesn't have a red or a blue next to its name. Disability affects anybody, regardless of your political affiliation. So this is a benefit to all of us,
Other
regardless
questions?
of party affiliation.
Representative McFarland.
Thank you, Mr. Chairman. As I'm trying to parse this bill and how it should be read, I look at on page, I guess it would be page 3, or the second page of the actual bill text, line 3 to 6, 354A16A.3, where it talks about the standards used for complaints alleging employment discrimination, but those do not apply for other kind of circumstances. So if we think about a scenario, let's say hypothetically a non-employment program like Hunter Education, what legal standards would the courts use to interpret otherwise qualified, and where is that defined in this bill?
You said Hunter College?
I'm saying, as an example, Hunter Education. I mean, we could talk more broadly.
Yeah.
You've been talking about IDEA, and I think we all understand that in today's world, even with the federal rules, IDEA often does not apply in the same ways in private organizations as it does in the public schools. But let's take that aside and just focus on the hypothetical of Hunter Ed. What would otherwise qualified mean there?
Well, this is only, I mean, like, we could talk about specifics, and I appreciate your question because, this is only addressing anything that comes from state or federal funds. This isn't talking about private organizations. That's a whole other, I think, bill. So I don't really want to get those two things mixed up. And IDEA, just for clarification too, like, that's for students that need academic support for a disability. A lot of students that have a disability don't necessarily need academic services or have an IEP. This protects them here. It's anyone that has a disability and a 504, which kind of goes above and beyond in some ways, because you can take that 504 plan and incorporate it.
Yeah, respectfully, if you could just focus your answer on my question around Hunter Education and the meaning of otherwise qualified and where that's defined in here.
I don't quite know your answer, and I can look it up as best as I can. Like I said, I'm not a legal expert, and I don't have the text in front of me too, but I could look it up.
All right. Other questions for this witness? Seeing none, thank you very much.
Thank you, Chair.
Next, I'm going to call on Michelle McConaughey, please, and next on deck will be Lisa Bogler.
Hello.
Hi.
Thank you for the opportunity to speak today. My name is Michelle McConaughey, and I am a deaf community member and executive director for Northeast Deaf and Hard of Hearing Services. Here to testify in support of the HB 1593. Like a deaf person, ASDEC is not a convenience for me. It is a necessity. Every day, the deaf and hard of hearing community navigates systems that are not designed for people like me and mine. Or when I talk about deaf and hard of hearing, I'm talking about deaf, blind, older adults with hearing loss, people who wear hearing aids, all of that under that spectrum. Whether it's accessing healthcare, understanding public safety announcements, communicating in government offices, or participating fully in my community, barriers remain constant and adopted. HB 1593 represents more than just a policy. It represents dignity, equity, and the recognition that the deaf and hard of hearing individual deserve equal access to information and services. Communication is a fundamental human right. Without it, we are excluded from decisions about our health, our safety, our education, and our future. Too often, individuals with hearing loss are expected to make do, rely on family members to interpret it, struggle through lip reading, and not everyone can lip read, to accept inaccurate accommodation. That is not equity, equality. I don't talk very well. Equality. started on collision. When Communication Access is provided, qualified entrepreneur, captioning, FM system, accessible technology, we thrive, we contribute, we lead, we work, we pay taxes, we raise families, we participate fully in civil life. Accessibility.
Thank you, ma'am. Your time is up.
Wrap up?
Your time is up, but if people have questions, people have questions for this witness. Seeing none, thank you very much. Thank you.
Yep.
Next, Lisa Bodwin, and on deck will be Adam Thompson.
Good afternoon, Chairman Lynn and members of the Judiciary Committee. For the record, my name is Lisa Bodwin. I'm here representing Strategies for Disability Equity. And I urge you, Strategies for Disability Equity. I support HB 1593. Federal disability anti-discrimination laws are not only civil rights protections, they are fiscal guardrails. The long-term impacts by the feds of weakening federal protections will shift people out of community, out of the workforce, and into far more expensive public programs, increasing the costs of institutional care, reducing tax revenue from the employment of people with disabilities, expanding reliance on Medicaid's home and community-based costs, and SNAP and other government benefits. When people with disabilities are excluded from rental housing, denied reasonable accommodations, or pushed out of community settings, the alternative is not independence, it's congregate care. Congregate care around the nation costs somewhere per individual $160,000 to $300,000 a year. Medicaid home and community-based services, IDEA, and other federal protections are a bargain for the government. When students with disabilities don't have their right to access education, they are not staged for success in employment, and that means that they are not in the workforce even half-time, part-time, paying their way, paying for more of their food, and paying taxes. So we are looking at somewhere between $2,200 and $2,300 per year in added SNAP benefits if the weakening continues of SNAP. Medicaid's home and community-based service burden will increase somewhere between $5,000 and $25,000 per year per individual, depending on their care needs. And there will be lost federal tax revenue from underemployment, somewhere on average between $900 and $1,800 per year. And I already mentioned the cost of institutionalization.
Thank you. Questions for this witness? Yes, Representative McFarland.
Thank you, Mr. Chairman. I appreciate the witness bringing up the example of SNAP benefits, because when I'm reading this bill, one of my struggles here is, and I would ask the witness, how are we supposed to interpret financial assistance when it says subjected to discrimination under any program or activity receiving federal or state financial assistance? I mean, do pass-through funds qualified as indirect reimbursements qualified as spending a SNAP benefit in a supermarket mean that supermarket is subject to the penalties of the rule? Does a tax exemption for a church mean the church is subject to it? I'm not at all clear how we're supposed to interpret financial assistance in this context.
So what I can address the SNAP piece and supermarkets. Currently, people with disabilities who receive SNAP benefits utilize SNAP at grocery stores. There are no existing issues. This is looking to make sure that the same federal protections that exist now continue to exist should the feds continue to weaken federal protections. So the proposed bill is not looking to alter churches from their exemption from ADA in Section 504. It's looking to ensure that they continue to receive the same protections, which would lead to the appropriate accommodations and modifications, as well as supports that they need to be staged for robust community-based lives.
Are there questions for this witness? Seeing none, thank you very much. Oh, I'm sorry, Representative Smith.
Are you suggesting that if the federal government eliminates programs such as SNAP, that that under this bill, the state would pick up
No,
that?
no.
Could you clarify that?
One would hope that the state would make some modification, but not attached to this legislation, and that is not what this bill is saying. What this bill is saying is that if the feds decide they are no longer in alignment with Section 504 of the Rehabilitation Act that protects from housing discrimination, for instance, that New Hampshire would remain in alliance with people with disabilities, that they cannot be discriminated against in a rental application based simply on their disability. We don't, if the feds decide that they're not going to reauthorize the Individuals with Disabilities Education Act, we will have protections in place so that students with disabilities can get the education that they deserve, so they don't become $300,000 per year institutional care costs to the state of New Hampshire and other,
Other questions for this witness? Seeing none, thank you very much. Next, Adam Thompson, please.
Good afternoon, Honorable Chairman. Thank you, Honorable Representatives. I appreciate that the opportunity to speak today. My name is Adam Thompson. I'm a resident of Scenic and Historic Ward 3, Nashua, and I'm hoping that you guys will support this bill. I'm a disabled veteran, and at this core, this bill is about stability, clarity, and continuity of civil rights protections for Granite Staters with disabilities. For decades, Section 504 of the Rehab Act has served as a foundational protection against disability discrimination in programs receiving public funding, federal programs. It ensures individuals are not excluded, denied benefits, or treated differently because of a disability. 1593 brings those principles directly into New Hampshire statute, and that matters. Federal law can change, administrative priorities can shift, and court interpretations can evolve. But the people of New Hampshire deserve consistent protections that do not depend on possible federal changes or uncertainty. This bill will ensure that if federal standards are weakened or altered, disabled Granite Staters are not left without recourse. It creates a clear state-level cause of action, it provides legal clarity, and it reinforces that disability non-discrimination is not conditional. It's a principle that Granite Staters uphold here at home. This bill is not about expanding government. It's about codifying expectations that many institutions already follow, just codifying it. It's about ensuring that individuals with disabilities have the same opportunity to participate in education, healthcare, employment programs, publicly funded services as everybody else. Disability touches every community. It cuts across party lines. It cuts across geography, and it cuts across income. New Hampshire has a long tradition of embedding fundamental rights into our own constitution and statutes rather than relying on federal law. We protect free speech and religious liberty in Part 1, Article 22 and Article 5 of our state constitution. We protect the right to bear arms in Part 1, Article 2A. Our courts have implemented Article 19 to provide strong privacy protections independent of the Fourth Amendment. And they're all recognized and enforceable under New Hampshire state law as well.
Thank you, sir. Your time is up.
I appreciate that. Thank you for your time. Disability can strike anybody, anywhere, as I learned in the Marine Corps when I became disabled myself.
Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you very much. I hope you guys have a great afternoon.
Thank you. I don't have any other pink cards. Is there anyone else who wishes to be heard? Yes. Please fill out a pink card, if you would. can go ahead and testify and fill out the card after you finish testifying.
Perfect, thank you. Good afternoon. My name is Carrie Duran. I'm a resident of Wolfboro, New Hampshire. Thank you, Mr. Chairman and members of the committee, for the opportunity to speak today. I am a mom of an amazing young lady. Her name is Katie. She's going to turn 15 in a couple of weeks, and she was born with a developmental disability of Down syndrome. And for the matter of the record, I am the legislative liaison for Lakes Region Community Services. We serve those with developmental and intellectual disabilities, children and adults. But today I am testifying as a mom. And this bill is so very important to me as Katie's mom. Every parent wants to make sure that their child has every opportunity that every other child is afforded. And this bill, and bringing this and codifying it within the state of New Hampshire, ensures that my daughter, Katie, continues to be able to have the opportunity to graduate from high school, to live on her own in an apartment, to have the support that she needs. She just started working this fall. She works 2 hours a week at a local coffee shop, and she loves it. She's able to have those opportunities that she needs to grow and learn and become a sustainable working adult. She wants to go to college. She wants to have the same opportunities that her older sisters do. I have 19-year-old twin girls. One's at UNH, one's at Plymouth. We go to visit. Katie wants to go to college. She prefers UNH over Plymouth. That's where she wants to go. But I want her to have those opportunities. And I urge you, please pass this bill and make sure that children like my daughter Katie, have those opportunities. Thank you so much.
Thank you. Questions for this witness? Seeing none, thank you very much. All right. Is there anyone else who wishes to be heard on HB 1593? Seeing none, I'm going to close the hearing on HB 1593. Now, let me tell you what I would like to do. But if anybody doesn't want to do that today, then we don't have to do it. Or if anybody in either side of the aisle, so to speak, wants to have a caucus right now before we do this, I'm happy to do that. And I say that knowing that the two bills, or at least one of the two bills that I think I would propose to exec, we may have some disagreement within the caucuses, particularly my caucus, and that's fine. So the two bills I would propose to exec now are HB 1590. That's the 20-week bill, and HB 1591, the dispersal of funds bill held by the Judiciary. So first of all, does anybody not want to have the exec session on these bills today? I don't see anybody. Second, does anybody on either side of the aisle want to have a caucus on this before we do that? Yes. All right. So we will have a caucus. All right. So we'll recess for about 10 minutes or so, and then we'll resume. 15 minutes. All right. 15 minutes. Fine.
No, he said, he was asked what bills.
Oh, it's 1590 and 1591. say, assuming, and I think this will be the case, that we finish, we're gonna hear two bills on Friday, and if we exec all the rest of the bills, which I feel very confident we will, then we will not have to come back next week except for session on Thursday or whatever. All right. So, all right, I'm gonna open, the executive session on, House Bill 1590, and the chair recognizes, Representative Manos for a motion.
Thank you, Mr. Chair. I would move ITL.
Is there a second?
Sure.
All right, hang on. Moved by Representative Manos, seconded by Representative Birch. All right, Representative Manos, do you wish to speak to your motion? All right, anyone else wish to be heard on HB 1590? Yes, Representative Scully.
Thank you, Mr. Chair. And I will be brief because you heard all of my arguments today. And it's probably best that the people who heard my arguments be voting on this. I do feel very strongly about this. I will obviously be opposing the ITL. I will be filing a minority report, and we will further the discussion in the House. Thank you.
All right, anyone else wish to be heard on HB 1590? Seeing none, I would ask the clerk to call the roll. The motion before us is ITL by Representative Manos, seconded by Representative Birch.
Vice Chairman Mannion,
Yes?
Representative Nodder,
No.
Representative Tripp,
Yes.
Representative Andrus,
No.
no clerk's missing, Representative Mattson,
Yes.
Representative McFarland,
Yes.
Representative Scully,
No.
Representative Petronel,
No.
Representative Birch,
Yes.
Representative Smith, Representative Horrigan,
Yes.
Representative Page,
Yes.
Representative Manos,
Yes.
clerk votes yes, Representative Long,
Yes.
Representative Bergeron,
Yes.
and Chairman Lynn.
Yes.
$13 yeas and 4 nays.
All right, Representative Manos, would you write the majority report, and Representative Scully, you will write the minority, which I assume would be OTP.
Yes, correct.
All right.
And when do you need that by, please?
Yeah. So you know what, on all the reports, can I have the reports by, let's say, tomorrow at 5 o'clock?
I can do that.
All right. Yeah, sure,
One comment.
sure.
There are certain bills where one or another of us feel very, very strongly. And I would like to commend Representative Scully, who feels very, very strongly about a bill that this committee is now not supporting. But he has always conducted himself with decency and respect and, in a way, collegiality, and that those are rare qualities. And that's why I'm very happy that so many times we can agree on bills, so that the few times that we're not, we know that we still have good feelings about each other, and I'd like to commend him.
Thank you, Representative Smith.
If I may.
Second that, sure.
Thank you. I mean, you've always been kind, and I know you're trying to do your best, as am I. And let's just keep trying to do that together and to be nice to each other.
All right, so I'm going to close the hearing, the executive session on HB 1590, and open an executive session on HB 1591, and the chair recognizes Representative Smith for a motion. Is there a second? Seconded by Representative Tur. All right. Representative Smith, do you wish to speak to your motion? All right, anyone else wish to be heard? All right, so the motion on HB 1591 is ITL, moved by Representative Smith, seconded by Representative Tur, and I would ask the clerk to please call the roll.
Thank you. Vice Chairman Mannion,
Yes.
Representative Nodder,
Yes.
Representative Tripp,
Yes.
Representative Andrus,
Yes.
Representative Mattson,
Yes.
Representative McFarland,
Yes.
Representative Scully,
Yes.
Representative Petronell,
Yes.
Representative Birch,
Yes.
Representative Smith, Representative Horrigan,
Yes.
Representative Page,
Yes.
Representative Manos,
Yes.
clerk votes yes, Representative Long,
Yes.
Representative Bergeron,
Yes.
and Chairman Lynn.
Yes.
Yes. Unanimous, 17-0.
17-0. Anybody object to it going on consent? All right, and Representative Smith, could I ask you to write the report? Thank you. All right. So let me just, I think for Friday, in addition to the two bills we're going to hear then that we have to exec, we will have to exec 1416, 1593, 1419, and 1419, 1389, and 1384. So 1, 2, 3, 4, yeah. So I think 7 altogether, yes. All right. All right.
Oh, plus the two were here. Right. Okay.
So,
Mr. Chair,
yes. Yes, Chair Representative.
in the spirit of
Representative Birch.
close, in the spirit of good feelings, I just want to make sure our record reflects our appreciation to our temporary clerk doing a yeoman job or a yo-person job
Yeah.
today, in a job that I would be absolutely terrible at. So,
And as one who probably is absolutely terrible at it, thank you.
Yeah, I think it sounds to me like you've done a really good job, and I very much appreciate it, Representative Turner. That's very open. All right. Well, listen, we're out of here a little bit earlier than maybe I thought we would be. I appreciate everybody hanging in there, and I'll see everyone on Friday for we can finish up. Remember, it's Friday. It's at 9:00. Friday, 9:00. Where? And here, I think you know what? Check I think we're here. I'm pretty sure we are in this room on Friday, but I'm not absolutely positive.
and for Democrats, 8:30 at the end of the hall.
Where did this all actually not?
He's not. Oh.
I know it's supposed to go to. Do I need to
Yeah,
arrange
we're in
this?
I think, you know what, I honestly don't, I think it goes to Kristen.
We are in this room. Oh, that's good.
Wow. We're in the same room? Okay. So, all right, so we'll be in this room on Friday.
Oh, this goes in there too.